Now, session, Page Whitaker presiding. Open out on the order.
All right, good morning, everybody. We are in session for this ongoing criminal trial. We're doing motions today and possibly for the next several days. For the defendants, I have not met y'all yet. You have not met me. I'm Judge Whitaker. I am the new judge who has been assigned to take over this case and preside in this case from here on out. As I said to the attorneys about 10 days ago when we had a scheduling meeting, I am going to encourage the parties to engage or re-engage in any kind of plea negotiations that might be fruitful. I suspect that for both sides of this case, there is a good bit of uncertainty and a good bit of risk with continuing with this trial, with potential appeals, you name it. So just bear that in mind, and we will go ahead and get started with the various motions. So the first motion that we have is, well, they're not in any particular order, but I've tried to put them in an order that I think makes sense. And the first motion that I am going to deal with is the motion filed by the state, essentially for a gag order on the defense. And with regard to all of these motions, I've read the motions, I've read the responses. If a response was filed, I have read any replies that got filed. So we don't need to take up court time rehashing what's in the motions. They're all well pled. If you have something that you want to add that was not in your written submissions, I'll listen to that. But with regard to the state's motion, which they didn't title for a gag order, but what it essentially is there anything further from the state that you would like the court to consider?
Adrian Love, Your Honor. For the state, Judge, we will rest on the authority that we have presented to the court and point out to the court that since the time of this filing, other instances similar to in nature to the ones that we pointed out to the court have occurred, and we would just simply ask the court to afford the relief requested in the state's motion.
All right, thank you. And anybody from the defense who needs to add anything to what's been filed in writing?
Good morning, Your Honor.
Good
Doug
morning.
Weinstein for Diamante Kendrick. We will stand on our response. The only other thing I'd like to add is to point the court to the case of WXIA TV v. State 303 Georgia 428, which discusses the presumptive unconstitutionality and issues with gag orders as prior restraint. That case is with respect to the news media, but there is some analogous language in that, and I'd just like to point the court to that. Thank you,
All
Your
right,
Honor.
thank you. All right, with regard to this motion, you know, I know that there were some things in it that suggested that certain of the defense lawyers might be running afoul of bar rules, and if they choose to take action that might put them in that kind of a situation, that's kind of up to them. And if there is a complaint filed, then they will have to deal with it. But I think that in regard to the propriety of doing that in this case at this time, I'm going to deny the state's motion. Obviously, if facts change and the state or the defense at any future time believes that it would be appropriate to consider this issue again, please raise it again. But at this point in time, we are going to move forward without instituting any kind of a restrictive order for speaking with the press in the case. With regard to the media, I'm just going to remind any of the media actors that are recording this case that the Rule 22s that are in effect in Rule 22 period only permits recording when the judge is on the bench. not during any recesses, and not during any bench conferences. So let's make sure that we abide by that from here on out. I was having to reference some prior live stream that was in some of the motions that were filed and some of the responses, and notice that there were definitely times, at least in what I was seeing, that proceedings were being recorded when court was not in session, and Rule 22 does not allow that. So let's make sure that we stay within the bounds of Rule 22. All right. So the next motion that I would like for us to consider is Mr. Williams' motion, and I'm just calling him by who filed it. I know that everybody has joined in on everybody else's motions, but to essentially revisit Judge Krause's factual findings in her recusal order. Mr. Steele, is there anything you want to add to what's in the written filing? Go ahead.
Good morning, Your Honor.
Good morning.
Good morning, everyone. Your Honor, may I just step back for 1 second? Good morning, Madam Court Reporter. I am Brian, B-R-I-A-N, Steele, S-T-E-E-L. And along with the Honorable Keith Adams, represent Mr. Williams. Your Honor, what the Honorable Judge Krause found in her result, we don't take offense to, or we agree with, actually, but when she made some comments which were that this ex parte meeting might have been, I'm not looking at her order, might have been okay if it was done in open court. I strongly, and Mr. Adams, Honorable Mr. Adams, strongly disagree with. And the reasons are in the joint affidavit of Mr. Adams and myself, dated July 8th, 2024. And what happened here is you have a witness, Mr. Copeland. He was sworn on June 7th of 2024, and he invoked a privilege. To my understanding, Your Honor, he did not have a privilege to invoke. The state, and we didn't have notice of it at the time, but the state ordered, or maybe we did have notice. I didn't have the motion, but I had the order, I believe. The state asked the Honorable recused court for an use immunity. So nothing that Mr. Copeland can use could be then turned around and prosecuted. So the way I understand the law is that protected anything that Mr. Copeland said was like an umbrella over him, so that anybody, federal courts, they could not use this testimony, but he could still be prosecuted. Somehow, according to the transcript, which is the ex parte hearing transcript, June 10th, 2024, there's the recused judge, Ms. Love, Ms. Bumpkus, B-U-M-P-U-S.
All right, and let me interrupt you for just a second. I've read the entirety of that ex parte transcript, so I'm familiar with what happened in that.
So my position is nothing there was good. Everything was wrong. And I believe, as stated in the affidavit and the motion, that there was intimidation put upon the witness. To change his statement, he made it very clear, send me back to the DeKalb County Jail. I'm not testifying. I have a case for the court. And based upon what you just said, if I could just get that case.
Okay.
And I'll be right back.
All right, while Mr. Steele's looking for that particular case, just a heads up to everybody else that's going to be arguing case law. If they want to present a case, try to go ahead now and be getting that at your fingertips, okay? Is this a case that's not cited in your?
Yes.
Okay.
May I approach?
Thank you. Thanks.
So, Your Honor, I just provide to this honorable court and prosecution in one copy to the Honorable Douglas Weinstein of Archer, A-R-C-H-E-R versus Maryland. It is 859A, as in Elisa 2D 210 2004 case. And on starting on page 6 of 22, Your Honor, of the copy I've given the parties, on the right-hand side, right in the center, the Maryland court explains that here Bailey had been convicted, sentenced, and the time for filing an application for leave to appeal his guilty plea had expired. Thus, he had no Fifth Amendment privilege to refuse to testify. Contempt proceedings were therefore an appropriate response to Bailey's refusal to testify. So it's the same situation, except he pled guilty. Mr. Copeland was never charged. He's called an unindicted co-conspirator. It's announced by the state. On page 10 of 22, the appellate court in our sister state goes through what happened with the judge. Now, this is not ex parte. This is in open court. So this gets to what you asked about Judge Krause's findings. And what the judge said on page 10 of 22 on the left-hand side in the center, first full paragraph, we find that the trial judge's efforts to persuade the witness to testify went too far. If Bailey persisted in his refusal to testify, Judge Prevas, P-R-E-V-A-S, had the option of either initiating direct contempt proceedings or constructive contempt proceedings. The authority to initiate contempt proceedings, however, is not a license to intimidate a witness into testifying. The purpose of the contempt power is to provide a means for a judge to uphold the dignity and integrity of the judicial process. And then skipping down to the next paragraph, similarly,
Can I interrupt
Yeah,
you?
of
And
course.
let's not skip down, because I think that part we're skipping is maybe important too, because it talks about the specifics of what that judge did in this
Yes.
case. So what is that?
Okay, well, he did a lot of things. But what the court is referring to, under the circumstances of this case, the phone call to another judge in the presence of the witness, the threat of life imprisonment as a sanction for contempt, and the suggestion that the other judge will give Bailey the longest possible penalty for contempt detracted from the dignity and integrity of the judicial process rather than uphold it. Similarly, it was unnecessary and excessive to instruct Bailey on how he could testify in the Archer case. Mr. Archer was one on trial. Bailey was represented by counsel who could have advised him concerning the various testimonial options if that was deemed necessary under the circumstances. Even if Bailey was unrepresented, it was not in the province of the court to suggest to the witness how he could testify to avoid a contempt sanction or how to allay his fears of testifying. In either case, it was not the function of the trial judge to suggest to the witness that he could testify favorably to the defendant, Archer. Specifically, Judge Purvis advised Bailey that he could testify favorably to the defendant, and there is nothing that anybody can do to punish him for that. That admonition was incorrect because Bailey could be prosecuted for perjury. So it goes on. I mean, there's great language. And the reason I use it, I understand it's not binding precedent, is it's hard to find a case like ours, but I searched and I found this. And what happened here, as the court is aware, just to highlight, because I heard what you said, the witness said, can I have 2 weeks to go home on house arrest instead of in the county jail? His child was having a birthday. That was a big deal to him. And then I'll make a decision whether to testify or not. I want to think about it. That answer should be from the court, because the court can do anything in contempt. It can give a fine. It can give weekends. It can give house arrest. It could do nothing. It could say you satisfy your contempt. That answer to that question was done by Ms. Hilton in front of the judge. Ms. Hilton said, no, you cannot. You have to go to jail. I find that offensive. This is my words. And that's why I'm disagreeing with Judge Krause. Number two, Mr. Copeland said in that meeting, everything I said was a lie. I've never told the truth in my life until this statement right now. That is like bullseye of Brady. It was hidden from us. It came out later, but it was attempted to be hidden.
All right, so that's in the context of another motion of yours, right? So let's focus on this motion for now.
My point is, nothing was done appropriate. I mean, and I don't want to get into, and the state actually filed a motion later saying the Honorable Judge Krause already ruled on this. I didn't know that they would do that, but I already said I'm not accepting those factual findings, respectfully, because they're wrong, A, and B, they weren't even needed for the finding. Another issue that came up is Mr. Copeland was told how to testify. I don't know how this happened because I don't have the questions. But Judge Glanville told the state in front of Mr. Copeland and his lawyer, didn't you give Mr. Copeland the state's questions that they're going to ask him? I don't have those questions. The judge said to Mr. Copeland, remember what Miss Love told you. Unless you tell a big whopper of a lie, these are not quotes, you're not going to get in trouble. That's not in the transcript. So something happened outside the transcript. Those are just a few issues. There are more. They're all in our affidavit. But those are a few issues that when Judge Krause said everything that was done, if it was done in open court, was appropriate, everything that was done is intimidating a witness. And it changes the complexity of the case. Because what you will find out is Kenneth Copeland, these are my words, made misstatements to law enforcement. He made 6 statements. They're all audio, video recorded, except for 2. They track over 16 hours. The judge told him, and Miss Hilton told him, and Mr. Copeland said, you previously told me, meaning Miss Hilton, I could just say I don't remember. I don't recall. And the judge said, yeah, you won't get in trouble for that. Well, what that does as under Georgia law is that triggers a prior inconsistent statement, which is all that the state wants him. Mr. Copeland is just here for his prior consistent or inconsistent statements. And that's what happened in the Archer case. That's why they're saying the judge said to Mr. Bailey, you can even testify for Mr. Archer. You won't get in trouble. because, and it explains in the Maryland case, because that would trigger and open the door to prior statements, which is all the state wanted. So to me, as found by the Maryland court, this is intimidation. There was nothing appropriate, and the Honorable Judge Krause, I'm confident, did not have this case, but I respectfully disagree, and that's why I wrote that motion.
All right. Anybody else? And I know that there is another, or there are a couple more motions for mistrial based on the ex parte that talk about coercion and things like that, and I'd rather take those up in the context of those motions. So if that's what you want to argue, hold off. Otherwise, come on up.
Your Honor, good morning. Max Shard on behalf of Shannon Stillwell. Of course, under the Harvey rule, I have joined Mr. Steele in his motion. I would like to, I guess I disagree with Mr. Steele in one small aspect. He is seeking to challenge the findings of Judge Krause, the factual findings, is the way he's articulated it. And I, too, have concerns about the order in the respect that it suggests that the ex parte meeting was or could potentially be appropriate. I don't believe it was appropriate at all, and I know that we're going to get further into that. But, Your Honor, I would, my disagreement in where I want to veer off from what Mr. Steele was saying is that I don't believe that they're factual findings. They're not necessary for her ruling. I believe that they're mere dicta. I don't believe that they're binding on you at all. What Judge Krause's order said, I believe that you independently can take a look at the transcript and make your own determination about whether the ex parte meeting had an appearance of impropriety or whether it was in fact improper, which it certainly was. So I just object to the characterization of these as factual findings because I don't believe that they are. I believe that they're merely dicta, and I believe that you're able to make that assessment on your own. Should you view them as factual findings, I, of course, join Mr. Steele in his objection to those quote-unquote findings. That's it. Thank you.
All right. Anybody else from the defense? All right, I'll hear from the state. And I know you haven't had a chance to see and absorb the Arnold rule, I think Arnold, the case that Mr. Steele just, Archer, shared with us before now, but.
Your Honor, I will use it as he has presented and just point out the most obvious omissions and distinctions that I see present with the Archer case. Mr. Steele stated to the court that Mr. Copeland had no privilege to invoke. He spoke about what did or did not happen during the meeting, during the hearing in chambers. I would ask that the court, as the court has already read the transcript, that the court take note of the differences between what occurred in the hearing and what Mr. Steele has represented to the court. As it relates to intimidation, Mr. Steele asserts that a statement made by Ms. Hilton essentially is part of what makes the hearing improper. The state has cited in its motion or its response to the court cases that support the state's position that this hearing was not improper. Essentially, in order for, as this is a motion to challenge factual findings, I'll speak to the factual findings that have been challenged. Again, Mr. Steele cites that Judge Krause's finding the way he said it, if it had been made in open court, it would have been proper. The
All
court.
right, why don't I just put on the record, because I've got Judge Krause's order right in front of me, exactly what it is that I think we're talking about. And I believe, and Mr. Steele, you can correct me if I'm wrong, but I think that the factual finding, that's the second one you're challenging, if it even is a factual finding, is Judge Krause's statement. It is worth noting that this court generally agrees with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. Is that what we're talking about?
Yes.
All right. Okay, Ms. Love.
Thank you. And so given the fact that the court has at its disposal the transcript of the hearing, Your Honor, and given the case law that the state has cited to the court, specifically, Your Honor, Allen v. State, 336 Georgia App 80 at 81, citing King versus the state, a Georgia Supreme Court case whose site is 273 Georgia 258 at 264 through 265 as authority for its ruling that appellant had no standing to contest the grant of use immunity to a witness. And King versus the state itself ruled after an appellant complained that the trial court acted improperly by conducting a brief hearing outside his presence concerning the state's request for an order compelling a witness to testify at trial and confirming the use and derivative use immunity that would apply to that compelled testimony, that the hearing in question was not a part of the proceedings against appellant, and that while appellant, quote, might have preferred that a key witness not be ordered to testify truthfully in his trial, there is nothing in Georgia law that would have permitted him to object to the state's request for the order or that would suggest that appellant's rights were the subject matter under consideration and that appellant had no standing to address the matter of the hearing outside his presence. I bring up those two cases, Your Honor, as well as Gilbert versus the state, and that site for Gilbert, Your Honor, is 306 Georgia App 776 at 777. Notwithstanding Gilbert's waiver, however, his argument is without merit because Gilbert has no standing to contest the grant of use immunity to Lang. The court again cited King and pointed out how the defendant there had argued that the trial court erred by conducting a hearing outside of his presence to determine whether a witness should be compelled to testify against him in exchange for use and derivative use immunity. They go on, this court goes on to cite the portion of King that I just read to the court and goes on to say, on the contrary, the trial court was obliged to consider whether the testimony was necessary to the public interest, a matter which the defendant had no standing to address. In this particular instance, of course, there is the distinction that Mr. Copeland had invoked his right to not testify at a point where there was no, I'll agree with Mr. Steele, there wasn't a privilege to invoke. The point at which he said, I plead the fifth, is when he was asked, I believe, his age in years. The concern that we had, the concerns that we had, we presented to the court, and mainly it was that Mr. Copeland, as is recorded in the transcripts of the July 10th proceedings in open court, that Mr. Copeland had questions that he was attempting to ask the prosecutor, Ms. Hilton, and the person representing Mr. Copeland would not afford him that ability while we were just outside the courtroom. And Mr. Copeland was then called in with the jury in the box without having had the opportunity to have those questions answered. The hearing in chambers, as is reflected in the transcript, dealt solely with Mr. Copeland's rights, what he faced, what his obligations were. The state's action of moving the court to compel Mr. Copeland to testify is what precipitated that chain of events that led to that hearing in chambers. And we wanted to ensure that Mr. Copeland was aware of whatever it was that he had sought to gain clarity about before he was forced to come in before the jury. So our...
Yes.
Can I just interpose an objection? I don't have any problem with Ms. Love referring to the transcript, but if she's going to testify, I would ask that she testify as a witness. I don't believe it's proper that she proffers information. I believe if she wants to be a witness, which I do believe she is, she would have to be sworn in to testify and subject to cross-examination.
All right, thank you. So I have read the transcript, and the transcript is the best evidence of what happened there. And what we're dealing with is whether I can and or should reconsider, I guess, the factual findings made in Judge Krause's order.
So the state's position, Your Honor, is just as Judge Krause was the authority, the court tasked with making a determination regarding recusal. The court has been tasked with the responsibility, the assignment of continuing the trial. Judge Krause's responsibilities we submit to the court are Judge Krause's, not this court's. Just as each court that at each step in this process has its own set of duties, that one belonged to Judge Krause.
Okay.
So we would ask that the court deny the motion to challenge the factual findings of Judge Krause.
Anything else from the defense on this particular motion? Has there ever been an attorney invited to talk who didn't take the opportunity?
I took a pass a couple of times, Your Honor. Doug Weinstein for Mr. Kendrick. The only thing I want to add is that the King case and the Gilbert case are about a different circumstance than we are objecting to and complaining about here. That is a hearing about the issue of whether the immunity should be granted by the court. Presumably that was done in this case sometime prior to Mr. Copeland's testimony on the 7th. What we are concerned about, object to, believe violate our client's rights, is the ex parte meeting that took place in chambers on the 10th, far after that immunity decision was made, at least just speaking with respect to my client, Mr. Kendrick.
Okay, thank you. Anybody else? All right, with regard to just this particular motion, which is styled a motion to challenge essentially Judge Krause's factual findings in her recusal order. It appears to me to ask this court to almost sit as a reviewing court and find certain factual findings to be erroneous. And this court doesn't have an ability to do that. The time to have filed or sought a certificate of immediate review has passed. I can't really sit as a reviewing court over a fellow superior court's order. To the extent that it is a motion to reconsider that court's order, that's a little bit closer to something that I might be able to do, but I can't really do that either. That, as Ms. Love correctly pointed out, was a motion to recuse Judge Glanville. It was before Judge Krause, not this judge, and she granted the relief that the defense sought. I understand that the defense does not like some of what might be factual findings in there. There are other motions before this court right now for mistrial based on that, and I think it is more appropriate that I consider them in the context of that than going back and essentially undoing potential factual findings made by Judge Krause. I think I agree with Mr. Shart that this is probably dicta anyway, in that the essential holding that the court made was that the recusal was based on Judge Glanville's engaging essentially while making a ruling on the motion to recuse, and making kind of more than just the minimal necessary findings in his ruling. But I'm not going to reconsider Judge Krause's factual findings, so I am going to deny that particular motion, understanding that we still have other motions for mistrial to take up where some of the arguments y'all made just now might be more appropriately considered. All right. So I think that actually the next motion I'm going to take up is the motion filed by Mr. Williams that has a very long style, but that essentially asks that any other ex partes be revealed, that a neutral judicial officer take a look at everything in the case that has been sealed and make sure that it is above board, and then for a mistrial based on the alleged judicial misconduct that occurred during the particular ex parte that was the 10th of June, and prosecutorial misconduct there and prior to that. So I got from the clerk's office every sealed filing from the state or any of the defendants in any of these 6 defendants' cases. I've looked at all of them. There's nothing improper about any of them. I refiled them. The order that it accompanies the resealing, I'm sorry, not refiled them, resealed them, actually delineates each of the things that I looked at or the dates of each of those sealed filings. I'll note that a lot of those ex partes were defense ex partes. There's nothing wrong necessarily with something being done ex parte. We're kind of talking about this June 10th ex parte as though, ooh, that is such a horrible thing. And it may be, but an ex parte in and of itself is not necessarily a bad thing, and both sides have appropriately held ex parte communications about things that should be ex parte with Judge Glanville prior to this. So there's nothing in any of those sealed filings that the other side needs to see at this point or that was improper in my determination. All right. The next thing is the defense asking whether there have been any other ex partes that we don't know about. And so I'm going to ask everybody, and y'all know what ex partes you had with Judge Glanville, and you know what filings got made. And so is there any ex parte that occurred that is not connected to one of those sealed filings? And I'll ask the state first.
Your Honor, not being certain whether the seal filings include the transcript of the request from the state to have the hearing with Mr. Copeland, and not certain whether or not those sealed filings contain that.
Okay.
I can't say, but the state requested that we address the matter of Mr. Copeland's representation.
All right, and was that done in writing or was that oral?
The request was done orally with the court reporter there. Okay. We requested that the court allow us to address the matter and that it be taken down for the record.
Okay. All right. Anything beyond that?
Yes, there was also the state's request for a material witness warrant for one of the,
I think those are all reflected, and you may want to go back and look, but I know that there were material witness warrant requests from several different parties in the case.
okay.
All right.
So those are the ex parte matters that we address with the court.
Okay. Thank you. Mr. Weinstein? Anything? Okay. Mr. Carlton? Mr. Matthews? Mr. Matthews? Okay. Mr. Steele?
To my best memory, which I believe is accurate, there were 2 meetings with recused Judge Glanville. One was during voir dire. It is going to be the day, I could get you the date, but it's going to be the day that law enforcement execute a search warrant for the computer of the Honorable Eric Johnson. He's a lawyer in the case who's severed out now.
Okay. All right.
And that was announced in open court. I asked recused Judge Glanville whether we can have an ex parte. All the parties were here, and then everyone went. So when I say everyone, all the people here went into chambers behind, and there was conversation in front of a court reporter.
All right. And when you say all the people here, does that include the state?
No.
Okay.
The
So
state
you mean
was here.
all of the defense attorneys?
And the state was here when I announced that we'd
Okay.
like to meet ex parte. The judge, former judge reconvened, our former judge reconvened.
Okay.
We went into the chambers here. So I have no idea if that's something you looked at or not.
And I don't know whether that's anything I looked at, because that would have concerned a severed defendant. I would imagine it's in that case and not any of these 6 defendants. And I only looked at what was in these 6 defendants' cases.
I can't
But-
answer.
Okay.
And when I say who was here, yes. Honorable Mr.
Okay.
Matthews, Mr. Weinstein, Mr. Harvey, I assume Ms. Westmoreland, she's shaking her head. Ms. D. Williams, I know Mr. Adams was next to me, Mr. Sharp, and I presume Mr. Botts. He's shaking his head, yes. And the second one was also asked in open court for a meeting with the recused judge ex parte, and that was on the day before, or coming up to a man named Mr. White, like the color, was going to testify, and we had it at the bench where the court is, and that was Mr. Sharp, Mr. Matthews, Ms. D. Williams, myself, and Mr. Adams. And if my memory's wrong, I'd like them to correct me. That's who I remember being there, and it was on the record.
Okay.
So I don't know if you saw anything about that.
All right.
And that was the total that I've had with.
All right. Thank you.
Thank you.
Mr. Harvey?
Judge, just to be on the safe side, it wasn't, we had a in-camera meeting with Judge Glanville. When I say me, it was not ex parte, it was me, Ms. Westmoreland, and I believe A. Hilton. But it concerned a scheduling conflict in federal court
Okay.
that I had, and we resolved that. I just want to make sure that.
All right. I appreciate it. Thank you. Mr. Sharp?
Your Honor, to the best of my recollection, I recall being with Mr. Steele in the announced ex parte regarding that gentleman, Mr. White. I also believe there was an ex parte regarding another permission to interview a separate witness who was unrepresented at the time. I believe that probably is reflected in the sealed records. I can't recall if Mr. Steele was with me or not, but that also occurred, and that would have been before the jury was sworn. That was late 2022.
Okay. Thank you.
Mr. Steele is indicating that he was present.
All right. Okay, so that takes care of that part of that motion, unless anybody wants to inquire further as to any of those. Okay.
Oh, Your Honor, what's confusing to me, Your Honor, is in the transcript of the June 10th ex parte meeting that we've focused on, there is, within the transcript, there's a clear indication that Judge Glanville is aware of, as Mr. Steele alluded to, questions that the state is in possession of, that they seek answers from Mr. Copeland about and wish to pass these questions on to him. There is nothing in the transcript that indicates a discussion between, I believe it was Ms. Hilton that was in possession of this list of questions. There's nothing in the transcript that indicates a conversation that even suggests how Judge Glanville would be aware of these questions, the existence of these questions. And it just leads me to the inescapable conclusion that either the transcript is not complete or there was a separate meeting that occurred, because there's just no context to it. It just doesn't make any sense to me logically. So that's my concern.
All right, so I read that part of the transcript, and obviously I wasn't there, but when I read it, I just thought, I think Judge Glanville used to be a prosecutor, and he assumes surely you must have given them a list of questions. Now, I have no idea whether that's, if it was just like, surely you have a list of questions, or if there had been a prior conversation, and I will ask Ms. Love that.
Your Honor, I believe that since Ms. Hilton was the one present.
Or Ms. Hilton.
But I can say that I did hear Judge Glanville, I believe, in open court say something similar to that, but I will allow Ms. Hilton to address the specific.
All right. Ms. Hilton, was there some basis from something that had already occurred for Judge Glanville to have asked that?
No, Your Honor. We were very sure to only talk about what was happening, which was getting Mr. Copeland purged from his contempt. So I made it clear that we weren't going to talk about anything substantive, and to talk to the judge about any questions to me would have been substantive. So we never talked about any questions with the judge prior to Judge Glanville saying that during the meeting. All
right, and was everything that occurred in that meeting, other than the times when Judge Glanville stepped out so that Mr. Copeland could talk to his own attorney and I believe talk to y'all, was everything else recorded?
Yes, Your Honor.
Okay, from the outset of that meeting?
From the outset of the time that I entered the room, everything is recorded.
Right, because you weren't there at the beginning of it.
Correct.
But you did not have a conversation with Judge Glanville prior to when you came into chambers and it was being taken down?
Outside of the normal,
how are you doing? How was lunch? Yes.
Correct.
Okay. And Ms. Love, you were in there at the outset. Was it recorded, taken down from the outset?
Yes.
Okay.
I asked that it was. She was there from the beginning. And as I stated earlier, the only other instance that we spoke on that was also taken down.
Okay. All right. And that was earlier that same morning?
I think it was the Friday.
The Friday before? Okay. All right. All right, so based on that, I don't find that there was any other untranscribed prior meeting between the state and Judge Glanville regarding Mr. Copeland and what they discussed in that June 10th ex parte. All right, another part of this motion is a list of purported slights and misrepresentations by Ms. Love that I'm not going to go through in more detail. They're in the motion. I'm just going to say, Ms. Love, make sure that your representations to the court and in court are accurate and professional. All right?
I will continue to do that as I have, Your Honor.
All right.
The court require all parties to make certain that that is.
Okay. All right. With regard to Judge Glanville's comments, I mean, he's off the case at this point. If we want to endeavor to craft some sort of a instruction to the jury, you know, I'll consider something that y'all want to present to me. But I know in particular, Mr. Steele, you took issue with, apparently at some point, Judge Glanville used some adjectives about you, specifically unprofessional and unprepared, that are bothersome to you, and I can understand that. I would also say that not only is that in the past, but if that was in front of the jury can see for themselves how you present, whether you're professional, whether you're prepared, and so that ought to take care of that. And this court is going to instruct the jury, just like is done in every case, that nothing that the judge says, no matter whether it's this judge or the prior judge, is evidence. It's not supposed to indicate any kind of a bias one way or another. And so I'll give those curative or those instructions anyway. And if you want something additionally curative wise, I'm willing to entertain that as well. Okay. All right. So given that Judge Glanville is now recused from this case anyway, and I have instructed Ms. Love to conduct herself with professionalism, I am going to deny the motion for mistrial as it is sought and on the bases on which it is sought in this motion.
Your Honor.
Yes.
I just asked for clarification whether the court is finding that there were any unprofessional or...
I am not making any such finding.
Thank you.
Yes.
I think we just, maybe I was lost for a second. I think we switched to a place where I didn't believe we were at, or I didn't understand the discussing regarding a mistrial. I didn't really understand us to be at that point in the motions yet. And I just wanted to be clear for the record, to the extent that a mistrial was denied. Mr. Stillwell, it has been we never requested a mistrial.
Okay.
And to the extent that a mistrial has been denied, I just want to be clear that Mr. Stillwell has not requested a mistrial. And when we were going to move on to Mr. Harvey's specific request for a mistrial,
yeah, I hadn't gotten to that one yet. Okay. All right. I appreciate that.
I just want to make that clear for the record.
Okay. Thank you. All right. So now we get to the motion to disqualify attorneys Love and Hilton, the two of the main ADA prosecutors in this case. And the basis for that, this is also filed by Mr. Williams, is that they assert a need to cross-examine Mr. Copeland, attorneys Love and Hilton, and Judge Glanville with regard to the ex parte. Anything that, Mr. Steele, you want to argue that's not in your motion with regard to this? And I do have a question for you about one thing that you said.
Yes, Your Honor.
You want me to ask my question first?
Whatever you tell me.
So in your paragraph 3, you assert that Judge Glanville provided legally incorrect information to Mr. Copeland. I just want to make sure I'm clear as to what you assert that legally incorrect information is.
Okay. So going back to what you've read and digested, June 10th, 2024, ex parte meeting, the use immunity, as we discussed earlier, just protects Mr. Copeland. What Prosecutor Hilton and what Judge Glanville were telling Mr. Copeland was, you can say lies, as long as they're not big lies, and you will not be prosecuted. He could be prosecuted for perjury and false statements.
Okay, and when you say that, do you mean when it was mentioned that if you say, I don't remember,
No.
you can't be prosecuted?
No, I have to get the transcript in front of me, but it was as long as Ms. Love told you, which is not in the transcript, but the Judge Glanville said, as Ms. Love previously told you, remember is a word used, unless it's a big whopper of a lie, you will not be prosecuted.
Do you have access to the transcript right now?
May I step back?
Yes, and of course, I thought I brought it up here with me too, but I don't seem to have it in front of me either. Can you go see if it's on my desk somewhere? I don't know how it couldn't be here, but thanks.
May I approach?
You may. And I'll give that back to you. I've got a copy somewhere. Just given that we're using a borrowed bench in courtroom, I don't have everything at my fingertips. All right.
But he
Okay.
handed me from the transcript of the ex parte hearing, June 10th, 2024. He directed me to page 40. It's Judge Glanville speaking, line 20. What will get you in trouble is you not, is you just invoking your Fifth Amendment privilege because you have been given immunity. Or as Ms. Love said this morning, remember, Ms. Love said if you lie, if you overtly lie about something, like if you tell a bold-faced, not big whopper, bold-faced whopper, then they can indict you on that particular charge. I mean that particular false statement. And then Mr. Copeland said that's what they're going to do. Then there's conversation by Ms. Bumpkus. That is what I was saying. You will be right back here. Then Ms. Hilton said on page 41, line 5, but if you say something that you know that you did not do, like you admit to something you know you did not do, whether you, and then Mr. Copeland said, like murder, don't have, like no statute of limitations, right? Ms. Hilton said on line 10, but if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it. Mr. Copeland saying, but y'all don't like ... His lawyer said, you could charge him with false statements and he will be back in jail. That's what I'm trying to say. And then Ms. Hilton on line 17 said, but if I know that you're lying about that, I do not intend to do that. If I know right now he's lying, I know he's lying, I'm not going to charge you because I don't know your reason for doing that. But I'm not going to charge you when I know you didn't do what you were trying to say you did now. And that can be part of this. I know you didn't do it. And the judge is there. So I hope that's answered your question. There's another space that I can find. I just need a second. But it's the judge saying you won't get in trouble. He says that throughout. You can say you don't recall, you won't get in trouble. There's also a place in here where the judge tells Mr. Copeland and Ms. Hilton that the statute of limitations, this is Ms. Hilton, the statute of limitations has run. In federal court, she says, I looked it up, in federal court it's a 5-year statute of limitations, in Georgia it's a 4-year statute of limitations. And if I could get that site for you, I'll tell you exactly where it is. What page? I'm being told 24, Your Honor, but let me check. Mr. Adams said 24 going into 25. Your Honor. On page 24, line 12 is what I see. Ms. Hilton says, and what we'll say, and Mr. Copeland and I, we've talked about this. I'm not sure what your concerns are, what concerns that you expressed to Mr. Melnick last week. But if you are, if any of your concerns deal with being locked up for anything, you can't. Like there's nothing that can happen. The feds, Ms. Bumpkus interrupts. Well, that's not, Ms. Hilton interrupts. It is true. Ms. Bumpkus, said, no, I said that's not his concern. Ms. Hilton said, if it's his concern for his safety, we need to know that. Like that's not expressed. So we don't know what the concern is that we can try to resolve the concern. This is what I'm saying, Mr. Copeland and I have had conversations before going to page 25, Your Honor, and here it is. I understand some of his concerns is potential criminal liability, hence why we gave you immunity. The federal statute of limitations done. The state statute of limitations done. So there is nothing, like I researched it this weekend again, both those statute of limitations for what you and I talked about, which is a 2015 or before done. You cannot be prosecuted for anything you testify federally or statewide, immune, period. So if that's a concern, there is none because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything in 2015, 5 years would have been 2020. Anything statewide is 4 years. It would have been 2019 finished. Your Honor, that's just not true. He's an unindicted co-conspirator in this case.
It sounds to me like they're talking about some kind of particular crime he might or might not have committed that he might be testifying about, and whether it obviously wouldn't be murder because, as he recognized, murder has no statute of limitations. But that sounded like it was a really particular crime.
You can't tell a person, I wouldn't tell a person, how about that? You can't be prosecuted because statute of limitations ran when you know he could be prosecuted in our indictment. The state is saying...
Agreed.
Yeah.
That appears to me to be talking about something very particular that they've had, like a particular crime they had conversations about, and not overall broadly, you can't be prosecuted for anything.
I don't know.
Okay.
I don't read it like that.
All
so, on the next page, page 26, it's again, Ms. Hilton, line 2, you will not, this order, I don't
Can I
know
interrupt
if
you for just a second,
Sure.
too? And I'm sorry, and I do want to hear, but is there anything else that Judge Glanville said that you believe is legally incorrect information?
Yes.
Okay, because I want you
We
to
need-
address that
We
as
need
well.
you to testify. Why do we need you to testify? That Mr. Copeland had to stay in custody till all 26 criminally accused have their case disposed of? That's not true.
Okay,
That's wrong.
Yeah. That is on, that's on page 36 of the transcript, lines 3 through, the discussion's kind of lines 3 through 9.
At some point, civil contempt becomes punitive. Civil contempt is supposed to make the person do the act. If the person's not doing the act, at some point, it's just not effective. So it has to be then given a date certain. You can't just hold a human being in custody until all 26 people, some of them don't have lawyers, forever.
Yeah.
That's what Judge Glanville said. That's the problem. So I'm just being transparent. We're going to have a situation where Mr. Copeland's testifying. At some point, I'm going to be able to ask questions. I'm going to ask him, was there a time on June 10th, 2015 that you found yourself in an office with a judge? Was this person who I'm pointing at there? He'll say, I believe no. But the transcript says, exactly, you spoke with Ms. Love earlier.
If we get to that, that may be something that you are able to examine him about. And I do think that, you have the transcript, and I know everybody has said, oh, there was Brady in there. Y'all got it all now, so it's not Brady anymore. If it even was before, y'all have it. You can use it at trial. I think you can appropriately examine Mr. Copeland if he decides to testify on some, maybe all of the things that happen in there. That may be something we have to hash out a little bit more. But let's not get ahead of ourselves. So with regard to legally incorrect information that the judge gave to Mr. Copeland, the two, page 40, 41, 24, 25, and then the one that I cited that you mentioned about all of, you may have to stay in jail till all of the co-defendants' trials on page 36. Anything else?
We need you to testify. Nobody needs him to testify. I mean, he could do whatever, it's America. He could do whatever he wants. He could sit in a jail.
Okay.
He has to pay penalty of perjury, but that's what judge. And they also tell him how to testify. Judge Glanville tells the lawyer first. If you remember, I could get you the transcript. You remember, you're shaking your head. Judge Glanville tells the lawyer.
Yeah, if you've got a transcript cite, I think the more clear we are, the better.
Okay. It's at the beginning when Ms. Love was there. Hold on one second. I'm being told page 30, line 5.
Okay, page 30, line 5 is Mr. Copeland talking.
Give me a second. Okay, so I start with page 8.
Page 8, Mr. Copeland's not there. Mr. Copeland doesn't arrive until page 23.
Right, and you asked where the former judge was asking questions that I'd like to know.
Where he gave legally incorrect information to Mr. Copeland.
Okay.
Which is what you put in your motion.
Well, okay, and page 8, though, if you take in consideration, starting on line 9, the former recused Judge Glanville is telling the lawyer for Mr. Copeland, now, to be fair, I think Ms. Bumpkus, as an advocate or anybody, has got to tell him, meaning her client, he's going to face some pretty significant cross-examination. And then Ms. Bumpkus says yes, or excuse me.
Was that legally incorrect? I would think, given this defense team that's been accumulated, that's probably accurate, even though it wasn't said to Mr. Copeland.
The judge, though, and the motion is, calling the judge and the prosecutors and disqualifying prosecutors. The judge has stepped out of his role as a judge. What judge tells a lawyer, tell your client, whatever the words are, you make decisions, obviously, but this is how I read it. Tell your client he's going to face significant cross-examination. And you know what else? The judge goes further. The judge starts telling him that the client, he's telling Mr. Copeland that the clients are guilty.
Mr. Copeland's not here at this point in time. This is his attorney, Ms. Bumpus.
All right, let me get that for you. It's when the judge is saying, they, meaning the accused, know more about your criminal conduct.
Okay.
But let me find it. Okay, on page 26, Your Honor. Line 16.
Uh-huh.
Mr. Copeland should be there.
Yes.
I'm just following what the court told me, 23.
Yep.
The court said, so if you, I believe Mr. Copeland, are worried about what the defendants may ask you because they may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those. Why?
Well, I think because this whole thing has to do with the fact that there was a 507 immunity order granted.
But he can be prosecuted for this case.
Which is not what the judge is saying there. Okay.
I don't know. I don't know any judge who gives advice like this. Then on page...
Well, if you are, I mean, if the topic of the meeting is to ensure that Mr. Copeland understands what it means that he just got immunity, which he certainly does not seem to at the outset of this meeting, and the nuances of that. I mean, that's a nuanced issue even for lawyers. It might be appropriate in the context of ensuring the client understands what could get him in jail for contempt and what the grant of immunity means, that he would explain to the witness, the potential witness, here's what it means. So, all right, I don't find anything improper about that particular one.
Okay. On page 30, it's not the judge now, it's Mr. Copeland speaking. Page 5, I believe he's speaking about the district attorney, but in front of the judge. You told me before you went to the judge with whatever thing you called, went to him with, and I believe that that's the use immunity order.
Right.
You told me I can't, when I'm asked a question, I can say I don't recall or I don't remember, excuse me, I don't know. You told me that if I plead the fifth, I mean something. Why would I plead the fifth to something I ain't do? And I said that you don't know what I did and what I ain't do, and then you was like something. So to me, telling a person you can say you don't know, nobody should tell a witness you don't know. That's all the state wanted. I don't recall, so they could get in a prior. It's in front of the judge. And then with Mr. Talking about what the judge did or didn't do for cross-examination of Ms. Hilton and Ms. Love, that was Brady, as you said, evidence. Yes, I have it now. But why wasn't I told that? And
So,
I want to ask questions.
Okay, so Judge Glanville is off the case. That all would go to whether it's appropriate for Judge Glanville to be on this case. That has been taken care of.
My understanding of the law is the motivation for any witness to testify is admissible evidence.
Right, and you can certainly ask Mr. Copeland about that.
And I'd like to ask the judge on page 36, line 3, until the trial is over, until all defendants have been, I got these 6 that we have right now, then there's another 6. Ms. Hilton said, no, there's another 12. The court said, there's another 12 or thereabouts that are still outstanding for various forms or another, and they're talking about he has to stay in jail. And I'd like to ask Ms. Hilton, Ms. Love said the same thing, and Judge Glanville, why would you tell him that when that is not the law? You can't just hold a human being.
All right, so you can certainly ask Mr. Copeland about that.
Okay.
I don't know that the prosecution's motivations are relevant to the issues that the jury is supposed to decide. And with regard to Judge Glanville, again, he is not involved in this case anymore. So I'm definitely not going to permit you to cross-examine Judge Glanville in front of the jury because, frankly, it's irrelevant, and he's been recused. So, to the extent that, do you have anything else with regard to why it is you ought to be able to have Ms. Love and Ms. Hilton removed from the case?
Yes.
Okay.
So, and just go back to your answer, last question, page 44, line 22, it's Judge Glanville speaking. And he said, okay, so you testify about some aggravated assault or murder, they can't prosecute you on it because that's what the order said.
Okay,
That's
hang
just
on.
not true.
I'm sorry, where are you?
Page
I may be on
44.
44.
Line 22, Judge Glanville
Oh, okay, I'm with you.
speaking.
Yep.
He said, okay, this is Judge Glanville, so you testify about some aggravated assault or murder,
Okay, so I'm
They can't
actually not
prosecute
with you.
you.
Page 44, line 2?
22.
22, okay. All right. Got
Judge
you.
Glanville speaking. Okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that is what it says on the order. And that's not true. They can prosecute him. They can't use his words.
Okay, all right, I will take all of that into consideration. I don't think that I'm going to make a ruling on this particular motion today. I want to take a full look at all of it in context, because I do think we have to consider it in context, but I will note that one down as well.
So let me then answer your question directly. So what's going to happen in my mind's eye is I'm asking all these questions to Mr. Copeland. He's answering however he answers. I am pointing fingers at the two prosecutors. That mandates that the jurors have to rate their conduct that happened outside the jurors' purview. I am saying that he was given, he being Mr. Copeland, was given erroneous legal information. He was encouraged by the holding of hands of Judge Glanville, Ms. Love, and Ms. Hilton, that they all intimidated, coerced, directed, encouraged, whatever the right word is, Mr. Copeland to do what they wanted him to do. It's in the transcript. We need you to testify, Judge Glanville said. Mr. Copeland will say, I don't know what he was going to say. But yes, I felt that. I felt that they were not going to let me out of jail. I can't then have, nobody should have, then lawyers stand up when the jurors now need to rank what they are doing in the case. Their conduct is at issue. I'm not making them witnesses. I'd rather they stay on, to be quite frank with you. They made themselves witnesses. And the reason is because they injected themselves in such a, my opinion, inappropriate communication with a court and a sworn witness who did not ask any questions. The gentleman was represented by known counsel. He says, and it's in here, I could give you the page, but there's no reason. Take me back to the jail. Judge Glanville said, do you want to talk with your lawyer, me, or the state? Why would a judge say speak with the state and go around the lawyer, even in front of the lawyer? So all of this, to me, is very at the heart of that gentleman's testimony, his credibility, and it invokes and puts into effect the testimony and credibility of Ms. Love, Ms. Hilton. I can't ask anyone on the earth. I have a transcript, but I can't ask Mr. Copeland, why did Ms. Love tell you? Or tell your lawyer, if your lawyer told you. And I'm not gonna, I understand I have to stay away from attorney-client privilege, but did you ever find out this statement? And if his answer is yes, because Judge Glanville said, remember Ms. Love told you, we just read that. I want to talk about that. And then at some point, I want to ask Ms. Love, why would you tell a human being that he's going to just rot, in my words, rot in jail until 26 people are gone, which is not the law? And Ms. Hilton, why would you tell him that if he lies, and you know he lies, you're not going to charge him? Why?
Okay,
And those promises were not given to us. They were hidden from us. And Judge, this did come out. Your Honor, this did come out. I got it now. I understand that. But if you look back at June 10th, 2024 about 11 o'clock in the morning, not the ex parte hearing. Recused Judge Glanville comes on the bench. Please look at the transcript because I'm not verbatim. I understand that Mr. Copeland's going to testify. Mr. Copeland's put on saying, are you going to testify? He said yes, and we rolled into questioning. I don't know how it got away from the prosecution, Miss Love, Miss Hilton, Judge Glanville. By the way, he told us things that are specific on the case. He said in here, I could give you the number, I committed all these crimes. All these crimes include murder. He's asked about statute of limitations for murder. We don't get any of that. So for all those reasons, I'm going to cross-examine Mr. Copeland. I'm going to bring all that out. And the people who are at the heart of that conversation are witnesses as well. They should not have done it. Then they tried to hide it, which I'm bringing out as well. And then just, I don't know how, but by circumstance, fortunately, whatever the right word is, we did get the transcript. If you read the transcript, I asked Judge Glanville for the transcript. He told me it was privileged.
All right, so I think this is rehashing kind of old ground that's not relevant to where we are right now.
I want to bring it all up in front of the jury, though.
Well, we'll get there when we get there.
But this is not, I cannot call anyone else. It can only go in the mind of Miss Love. Why did she call the meeting? I don't know. Anyone else could answer. No one asked for that meeting. This is my understanding. And Miss Love stands up here and said, we needed to answer questions because Mr. Copeland asked questions. I don't see that. He's represented by a lawyer. I mean, I don't see that.
Okay, well, thank you. I appreciate it.
Anyway, that's the basis of calling. I heard what you said about Judge Glanville. That's the basis why I want to call Judge Glanville and ask why did he join the prosecution team. And I believe that that then dovetails into Judge Glanville saying wrongly that I was not prepared, wrongly that I was unprofessional. And then he later acknowledges that. But he says, I'm not going to instruct the jury. So the jury's never heard that. And I heard what you said, that you'll instruct the jury. But I'm going to argue that that instruction, that the judge has no role in the case except, it's not verbatim, but except to make sure that the parties, every party has a fair trial. I'm going to tell the jurors that didn't happen.
Okay, well, we'll see whether that's going to be something that is a permitted argument or not if we get to that.
Okay, but that's my strong belief that the jurors get to know that who the judge was for 18 months.
Mr. Sharp, you look like you want to say something.
Thank you.
And I'm trying not to focus on things that we're likely to discuss.
Okay, and yeah, remember that this is the motion to disqualify Ms. Love and Ms. Hilton.
Right. I would just like to stress one point that, Your Honor, I know that you have joined us and weren't there on June 10th. I think it's important to remember when we're talking about the potential to call the prosecutors as witnesses. My understanding, I know I didn't call an ex parte meeting. My understanding is that Kenneth Copeland did not request an ex parte meeting. My understanding is Caleb Bumpus nor John Melnick, who served as counsel for Kenneth Copeland, did not call for an ex parte meeting. They did not express any concerns. The state called for an ex parte meeting. And in the beginning of that ex parte meeting, with Judge Glanville explaining the need for the ex parte meeting, the state made statements to Judge Glanville that accused Attorney Melnick of violating his oath and of not fulfilling his professional responsibilities and representing Mr. Copeland. They strongly insinuated that myself and Mr. Steele were somehow in cahoots with John Melnick and were somehow, I guess, obstructing justice, tampering with a witness, intimidating a witness. They presented the judge. And mind you, this is an ex parte meeting where I was not allowed to respond. Mr. Steele was not allowed to respond. Ms. Love stated to the judge, well, Mr. Melnick sent Mr. Steele and Mr. Shard an email, and he may have inadvertently included us, possibly by mistake, and was communicating with them that Mr. Copeland would not be testifying. And we don't know what they have going on between them, and I guess we were just lucky to be inadvertently included, CC'd. Judge, I have the email. I believe it's in the record. I can show you the email. The state's not CC'd on the email. It's to the state.
Okay.
So that was a misstatement. Convenient. There's absolutely no... The reality is the state was meeting with Mr. Copeland behind the back of his attorney. The reality is the defense was pristine in their duties in dealing with an attorney and not with a represented individual. And somehow the state, in this ex parte meeting where we were not allowed to respond or even to hear the accusations, they suggested that the purpose of this meeting was based on this behavior by defense attorneys and Mr. Melnick, which was completely fabricated and offensive. And again, we weren't there. That's the problem with these ex parte meetings.
All right, well, I'm going to get a transcript. I have just typed a note to Judge Glanville's court reporter requesting the transcript of the request for the ex parte itself. So I'll find out what it said and I'll share it with everybody.
Okay, well, that's in the beginning of the transcript that you have. It's in the first 6 pages, I believe. In fact, page 3 to 4.
Okay.
Page 3 to 4, they talk about this email, and we have the email.
Oh, no. I know the email.
Okay.
I'm talking about, I'll get the transcript of the Friday request as well. But yeah, I've seen the email. It's made an exhibit, I think, to the ex parte transcript.
And just so we're clear, and the reason I say that's important, because again, why are they doing this? What was the purpose of the meeting? Because that couldn't have been the purpose, because their stated purpose was completely inaccurate. And I would invite the court, I believe it's in the record, but we can certainly provide a copy of said emails.
It's an exhibit.
Okay, because that's not an accurate rendition. And you know, I'd be happy to answer questions about what happened, but that was not accurate. And these are issues that now the state has injected themselves. As Mr. Steele said, we didn't do this. We didn't do any of this. In fact, we were excluded. We knew nothing about it. And it's improper, and the state initiated all of this, and it's not just what happened in the ex parte meeting, but why did it happen? And ultimately, there's only 2 people, I suspect 1, but we'll say 2, that really know why this meeting was called, because it wasn't called by, my understanding, Judge Glanville either. It wasn't called by his staff. It was either called by Ms. Love or Ms. Hilton. And we have the right to cross-examine them or examine them about that.
All right, thank you. Response from the state.
Yes, Your Honor. Again, Adrienne Love responding for the state.
And I want to hear what you have to say. I've got your response, that's your written response. It's pretty thorough, so let's highlight what needs to get highlighted without rehashing everything.
That was my intent.
Not to suggest that you would, but.
Your Honor, I'd like to point to the court, McGlynn, MCGLYNN versus the state, 342 Georgia App, 170 at 173 through 174. In McGlynn, the court notes while Webb dealt specifically with statements made by a trial judge, this court has previously noted that either judicial or prosecutorial intimidation that dissuades a potential defense witness from testifying, or the defense can, under certain circumstances, violate the defendant's right to present a defense. However, such analysis must be undertaken on a case-by-case basis. Here, we note, as did the trial court, that nothing in the record suggests that the statements made by the ADA to the witness were legally inaccurate or misleading. In fact, the ADA's comments seem to have been confirmed by the witness's own attorney, who, unlike the ADA, is charged with acting on the witness's behalf and protecting his rights and interests. As we observed in Terry, the potential for unconstitutional coercion by a government actor diminishes when a defendant's witness has consulted with an independent attorney. That these statements by the ADA were later perceived by the witness as threatening is wholly irrelevant to our consideration of this matter. The court has held that the state is duty-bound to inform the witness of the possible consequences of admitting under oath facts that could place the witness in legal jeopardy, including notifying the witness that the criminal law would be enforced to the full extent against those who violate it. And that's the court citing Murray versus the state, 157 Georgia App, 596 at 598. As of course the court has noted, we have included in our response the applicable case law that we believe is most relevant to the court's consideration of the motion to disqualify. In this particular instance, Your Honor, I would assert that the why of any particular proceeding is not a material issue, is not something that is relevant to the juror's determination of the guilt or innocence of either defendant in this case. It's not in any way. It's, if anything, it would be the effect of anything said on the witness themselves, and the witness himself could testify about that. In addition to the fact, as we stated in our brief, there were multiple people there as reflected in the transcript, and there's no reason to, there's no need to resort to an extreme remedy as disqualifying the prosecutors in this case, any more than we would have the right to cross-examine Mr. Steele and Mr. Sharp based on what they may have said to Adrienne Bean or anyone else in this case. So we would ask that the court simply deny the motion for such an extreme step as disqualifying Ms. Hilton and me, and we would base our argument on what we've presented in our brief.
All right, thank you. You know, something that's tied up with this issue is the fact that, there's been a motion filed with regard to it, and we haven't gotten to it yet, but I think the defense is correct, and I don't think the state opposed the fact that everything after at least the 14th and probably the 12th needs to be redone, and that is all of Mr. Copeland's testimony, or virtually all of it. And am I correct that the state pretty much concedes, agrees that that's true?
After the point where the motion to recuse was filed by defendant Kendrick.
Okay.
We don't disagree.
All right. So, and that was the 12th?
I believe.
Yeah. So, you know, we may be having a really kind of an academic discussion about all of this anyway, because if what the court is going to have to do, and I invite y'all's input on exactly how to instruct the jury about this, if we're going to be redoing Mr. Copeland's testimony thus far, we're probably, unless y'all decide you want to stipulate to parts of it, which you certainly can, we're going to be telling the jury to disregard it anyway. And if we're telling them to disregard it, then we don't need to talk about what might or might not have been significant in it, because we don't want them considering it. So y'all keep that in your minds as well. And that may be something we don't get to until tomorrow, but we have to sort of think about that as well. All right, so I am going to take this particular motion under advisement, and I'll get you a ruling quickly, but probably tomorrow.
Actually, consider one thing.
Sure.
Mr. Copeland testified hardly at all on the 7th of June 2024, but then did testify the 10th, 11th,
Right.
and then the 12th is what
Right.
you referred to. And I said, we'll take up that motion tomorrow. But there was a lot of exculpatory information. I'm not going to agree to strike all that testimony.
Okay, well,
want you to be
what I mean that we'll get to tomorrow is how to, and I'd love for y'all to get together on whether there are any parts of his testimony that occurred before, the testimony that occurred before can stay.
Okay, I misunderstood what
The
you said.
testimony that occurred after the motion was filed, if there are parts of that testimony that y'all can agree to, then that will be great because it'll save us time and we'll have better contours about what we're dealing with. So I want y'all to get together about that and we'll think about that probably tomorrow, maybe the next day, I don't know, but not today. But y'all after court today can think about that together with each other, okay?
The reason I stood up, though,
Yes.
I just wanted to make that introduction. The reason I stood up is the following. The state elicited testimony. Now, Mr. Copeland denied it, and they've done it with many witnesses before the Honorable Court took over the case. You've never had to testify in front of Mr. Williams, Mr. Huey, Mr. Kendrick, et al.
Right.
And you're intimidated, and that's why you're not testifying. I would need to show the jury that it's the state, and I have evidence now, and the judge that has been the person to intimidate a witness. So that's another issue when you're resolving this. Can the Judge Glanville, I heard what you said, but can Judge Glanville be a witness? Can the two lawyers representing the state of Georgia be witnesses? I need that in the case because...
Okay, let me ask you this though. Why can't you use the transcript to get that point across? I mean, it's right there in the transcript. What it is that you assert to be intimidation is in black and white in the transcript.
Because I'm intending to cross-examine or examine Lawyer Hilton and Lawyer Love.
I know you're
on how
intending
they-
to, but what I'm asking you, and I don't mean to interrupt you, but I want you to answer the question that I asked you, which is why can't you use the transcript to do that?
Because Mr. Copeland can't discuss. Why are you asking these other witnesses this? And what other witnesses, how'd you treat other witnesses? There's another witness named Miss Bennett who said basically the same thing. She was intimidated by the state. My point is, I can't ask Mr. Copeland what
But the
happened with these other
issue,
witnesses.
as I understand what you're saying to me, is that you want to get before the jury that the state and the court intimidated Mr. Copeland
Right.
into testifying, essentially. What you say is the intimidation is reflected in the transcript. Ms. Love's motivation for doing it, if she in fact tried to do that, is not the relevant issue.
But I have evidence of other witnesses who were treated not similarly, because I don't have any other evidence that there was some meeting between the judge and the prosecutors like there was in this, but that the prosecutors are doing the same thing with other witnesses.
Okay.
They are intimidating other witnesses,
All right.
and Mr. Copeland can't answer those questions.
Okay, but that you can argue because you will have, look, we see that it happened here. We've already heard that it happened from the mouth of XYZ witness. Imagine, it's every witness. I mean, that's the topic of argument. So I think that I'm going to look at all of it again, but I don't think that's a persuasive argument for why they need to be kicked out of this case. I think the transcript is what you need and what you have, but we'll take that up later, and I will think about that.
Thank you.
Okay.
Excuse me, Your Honor.
Yes, sir.
May I just briefly address something you said earlier?
Sure.
Well, I did argue with the court that everything after the afternoon of June the 12th is void and needs to be thrown out.
Right.
I do not, just for purposes of the record, I do not concede that this trial can continue.
I
that we can-
understand.
Okay, I just want to make sure.
That's a couple of motions from here.
Just want to make sure
still.
that's there, because you're asking us to meet tonight to go over what could possibly remain.
Well,
and I don't know that that's possible. Thank you, Your Honor.
Well, it's possible. I mean, unless I rule today that y'all have a mistrial that is with prejudice, it is certainly possible for y'all to meet tonight.
No, absolutely. I understand that. We'll follow whatever order
All right.
that you give, Your Honor.
All right, thank you. Okay, so the next motion is Mr. Nichols' motion for mistrial and objection to mid-trial substitution of trial judge. And it is quite lengthy and detailed with many subparts.
Well,
Mr.
Judge,
Harvey, are there things other than what is in the written motion that you want to
Well, there
talk
is.
about?
There is.
Do you want to
but-
come up here, or, I mean, it's fine if you stay there and hold the mic, that's fine.
Well, what I want to say is, I think our motion was in seriatim. Number one, we joined the motion for mistrial.
Mr. Kendricks,
Yes. So
Okay.
I think that needs to be addressed first. And then our motion was in the alternative, if you do not grant that motion, then we have a separate motion, which most of these defendants have opted out of.
okay.
So I think that would be the
Okay.
appropriate.
Fine
We're
with
gonna-
me. I kind of had a note that a lot of those two motions go together and kind of have to be considered together anyway.
Well, one, I joined theirs, they didn't join
Okay.
mine. So it's a
right.
second step.
That's fine. All right, so it's fine with me. We'll take up Mr. Kendrick's motion for mistrial first. And his motion asserts his motion joined by everybody else except for Mr. Stillwell, is that right?
No, I joined.
You did join this one. Mr. Kendrick's motion
If we're speaking about Mr. Kendrick's motion,
for mistrial filed July 23rd.
because we were so, I am, may I make my stance clear?
Yes.
On the record? Our stance, Mr. Stillwell's stance, is that this trial is completely broken. It's broken. There's error in this trial that would never survive appellate review. Illegal ex parte hearings have occurred. Our client's rights have been repeatedly violated. The defense has been mistreated in front of the jury by a partial judge. It's broken. We are also winning this case. We are put in an impossible position right now because our rights have been violated, but we do not wish to move for a mistrial. We are merely pointing out that this case is broken, and I filed a motion about that, and I will get into the reasons when it's my turn. But I am trying to be very careful to make it clear that I am not moving for a mistrial, but I have extreme doubts about the ability for this case to continue, and I am absolutely certain that my client's rights have been violated throughout this process. Of course, Your Honor, I'm just going to put on the record, this is your first day here, so I'm not insinuating anything about your performance here today.
All right.
Thank you.
Thank you. Okay. And, you know, it may or may not survive appellate review if it continues and if there is a conviction. That's not for me to say. Okay, so Mr. Kendrick's motion for mistrial, joined by everybody other than Mr. Stillwell, essentially asks for a mistrial with prejudice because the assertion is that the state wanted this mistrial, goaded the defense into it, and under those circumstances, if a mistrial is granted, and those are the actual facts, that any mistrial would be with prejudice without the ability to try the case over again. But the determination has to be made whether the state had the ex parte on purpose with the purpose of goading, to use Mr. Kendrick's attorney's word, the defense into making a motion for mistrial because the state thinks they're losing the case and wants to be able to do whatever with. If I got the concept right?
Yes, Your Honor.
Okay. All right. So this is also a lengthy and well-briefed, well-written motion. I will hear what you want to add that's not already in your written motion, if anything.
Thank you, Your Honor. I have nothing to add to that motion.
Okay.
As a lawyer, I feel compelled to speak to it, but I will sit down,
Okay.
given that I have no additional information. I would like to respond if the state does have something to add.
Okay.
I did not see a filed response from the state to our motion. I was served a response, so I'm not quite sure. I'm not quite sure what that's about, Your Honor.
Now, you know, sometimes they get filed, but they don't show up in Odyssey for a couple of days. Because y'all have been good about emailing the court when you file. I haven't actually checked Odyssey to see whether it's in there or not, but I would imagine that if the state served everybody with a response, they also filed it. If not, they need to. Okay, so that is a part of this motion. And another part of the motion is, well, I think you say as well that we'll need to redo the from 612 on. That's a part of this motion.
That is a part of this motion, Your Honor, yes, that there is a requirement that everything after 612 is void.
Okay,
And in that motion, we argue what I stated earlier, that I don't believe it's possible
That it's
to
not
erase
possible.
that information from the jury.
Okay.
Also, I'm happy to take any questions you may have.
Okay, I appreciate it. All right, so, yeah, so there are a lot of different grounds in here. There's the state sought it because they wanted the defense to ask for a mistrial so they could get a mistrial and try the case over again. That substantively speaking, the ex parte was a critical stage at which the defendants were excluded. And then the concept of, which we've kind of brushed over somewhat, that Judge Glanville's comments in the ex parte itself amounted to unconstitutional coercion of Mr. Copeland to testify.
Those are exactly my arguments. That's correct, Your Honor.
Okay.
There's three main issues, three main arguments that I put forward in that motion. The only thing that I can think of that maybe I did not sufficiently highlight is just the tremendous experience of the prosecutors and skill of the prosecutors in the state as both, in this case, as both attorneys and prosecutors. So I cannot believe that they would not have asked for this ex parte, conducted the ex parte in the fashion that they did it, unless they knew that they would be forcing us into a position to request a mistrial. As Mr. Shart has said, we are winning this case. The state's witnesses have not testified the way that I imagine they expected them to testify, and I do not believe that they should be allowed a do-over in this case, Your Honor.
All right.
But I'm not going to repeat what's already in
Okay.
front of you.
Okay,
thank
thank
you.
you.
Again, if you have questions, I'm happy to
All right.
answer any.
And then also sort of in this motion and asserted in a lot of the defense motions are what we again touched on, that Brady material arose from this ex parte and y'all have it now, so it's not a Brady violation anymore.
And that-
To the extent there was.
And that's not a real requirement
Okay.
in order to grant our motion, Your Honor.
All right, I just wanted to make sure I covered that as well. Okay. Does the state want to be heard with regard to anything not already in their response?
Yes, Your Honor.
Okay.
Just based on Defendant Kendrick's representations to the court and others that they're winning, and therefore we goaded them. If they're winning, then let's just keep it rolling, because the state vehemently objects to a mistrial.
Okay.
And I am unclear how we are arriving at the conclusion that the state, in conducting something according to the rationale presented to the court by the defendants so far, that the state never intended that they find out about, in an effort to cause them to do something. I don't know how those two can be squared with one another. So we would ask that the court deny the motions for a mistrial based on the state, based on anything. I'd point out that this is not the first or the second or the third motion for mistrial. The state has objected every step of the way. We continue to object to a mistrial. Again, if they feel they're winning, let's keep it rolling. And we would ask that the court just deny it. Of course, the court is aware that the issue here is not whether anyone acted improperly, but what objective the prosecutor is trying to achieve. It does not make sense to assert on the one hand that we want you to not ever learn about it, and on the other that we are intending that you be goaded into an act by our doing it.
Okay.
So, thank you.
There are issues here as to whether people acted improperly. Perhaps that does not go to the goading, but I don't want to, it's clear in my motion that we are arguing that there was improper conduct by both the state and the judge that violated Mr. Kendrick's rights. He has been locked up in Rice Street for 22 months. I have done everything that I can to move this trial along. I filed a motion, I believe at the end of March or early April, to try to get this trial moving at a more deliberate pace. That motion was essentially denied. I have no interest in retrying this case, Your Honor, and we are winning, I think, by any measure. So I'm asking for this mistrial, but I'm doing it because I have absolutely no choice but to do that, Your Honor.
All right, thank you. And I don't know whether this was, I think this was Mr. Nichols' reply to the state's response. So I don't know if it was with regard just to Mr. Nichols' own motion for mistrial or also Mr. Kendrick's motion for mistrial, but I think it's, the argument is applicable to Mr. Kendrick's as well, so I'm going to address it right now. Mr. Nichols argues that the state says that the defense's characterization is a mischaracterization of what happened in the ex parte, but does not offer their own characterization, and therefore they essentially aren't opposing it, and I should just take as fact everything that the defense said. And I do find that the prosecution did, in fact, oppose the characterization made by the defense and posit their own characterization. In their response, they say, quote, "the hearing in chambers was proper," unquote, and then quote case law. So that to me is not the state saying, yeah, your characterization is right. That is them saying, no, we were not trying to get a mistrial here. We didn't do anything improper. So with regard to that issue, I'm not finding with Mr. Nichols. Now, I am going to, in the context of taking under advisement the other motion that we talked about before, take under advisement the concept of whether what occurred in chambers was coercive, and if so, was coercive to the extent that under the cases like, I think, Wynn and Webb, it requires a mistrial. Because I think the concept generally was before Judge Krause, but not in the kind of detail that it is right now. So I do think that that is something that I can take into consideration and will take into consideration, and y'all have both briefed it, and so I'll get the ruling to you. As with regard to the propriety of the ex parte itself, we've kind of already talked about, I don't think that was the actual basis of Judge Krause's order on the recusal, so I will endeavor to make a substantive ruling on that as well. So that's another one that I'll probably give you my ruling tomorrow. Okay. So, making myself a note. All right, now to Mr. Nichols' motion for mistrial, which, in addition to everything else that's in Mr. Kendrick's, essentially says that there are reasons why the mid-trial substitution of another judge makes this impossible. And Mr. Harvey, I know.
I apologize. Can I interrupt you again?
Yes.
Thank you. I do that with, a smile and a request for permission.
Okay.
Again, I think there are several other mistrials with prejudice that have not been heard by you, and that would include Mr. Williams filed on July 10th of 2024, entitled in part, Motion for Mistrial Based Upon Judicial and Prosecutorial Misconduct and thus bar retrial. Mr. Shart, on behalf of Mr. Jackson, also has a mistrial with prejudice pending that I don't believe the court has heard. And again, I think in seriatim, if you decide on all of those, then I'll come behind these brilliant lawyers.
All right, I appreciate it.
Follow up.
So with regard to Mr. Williams earlier, prior to the, July 9th, honestly, I don't know that I saw a motion to recuse filed July 9th, but when we talked about all of the pending motions before, there was the July 10th motion for a fair trial and for mistrial on prosecutorial and judicial misconduct. That's one of the first motions I took up today. Is there another one? Yeah. Well, I did. That was one of the first ones. Is there another one other than that? Yes.
Mr. Williams is not asking for a mistrial. If you grant a mistrial, then that would be over objection, and that if you grant, I joined in the goading. See, I think it's a two-step process. You grant a mistrial or deny a mistrial. If you grant a mistrial, then there has to be a conversation about a plea and bar. So I'm joining. If you grant it, it'll be over objection, then I'm going to file a plea and bar. So I was just upfront with the court. So
but
you are
with regard to anything, is there any motion for mistrial filed by you on behalf of your client other than the kind of, not really omnibus, but multifaceted motion you filed July 10th that was for a fair trial to get all the ex partes for a mistrial based on prosecutorial and judicial misconduct?
On Friday, July 27th, I filed a response to the state's, you called it a gag order. And in that, the second part, I also filed an adoption that if you declare a mistrial, it will be over objection. And then I will be raising a plea and bar because it would be, the only reason to declare a mistrial is because the defense was goaded into it. So that is it. So.
Okay. All right. So, Mr. Harvey, I don't think Mr. Williams has another one. And then Mr. Shart, on behalf of Mr. Stillwell.
July 23rd at 3:07 p.m., a motion for fair and constitutional trial. I believe I'm I have a lot to say.
Yeah, and,
And I believe I'm similarly situated to Mr. Steele in many ways regarding that, because I do believe we're being goaded into moving for a mistrial. I do believe that case law supports that conclusion. I do believe that so much in this case has happened that has broken the case. I believe, and I'd love to be able to argue all of that, but I am not specifically asking for a mistrial unless jeopardy attaches.
okay.
And so that's where I'm at. I'm happy to argue that. I'm happy to argue that before or after Mr. Harvey or Mr. Steele.
Okay, give me just a second. Sure. You know what? I need to find the motion that was just referenced by Mr. Shard. Anyway, why don't we've been going for a couple of hours. Why don't we take a 5 to 10 minute convenience break? All right, we'll be in recess. I wanted to address to the audience is that there's been kind of a lot of up and down and back and forth and in and out, and that is distracting. So I know there may be times when you need to step out for a particular reason, and that is fine. But let's try to minimize that, because if it gets too distracting, I'm going to have to ask you to step out until all your business is taken care of, okay? So let's, if you got to go out, but then it can't be a up and down every 5 minutes thing. All right, thanks. Okay, so Mr. Short, yes, I saw your motion for a fair trial, and the reason I didn't register it as a motion for mistrial is because it's essentially not. It's saying if you grant a mistrial with prejudice, we're in on that. But otherwise, we'd like to, even though we think this trial has been a disaster, we would like to keep going because we think we're winning. So you asked that it be a constitutionally fair trial, and I guarantee to everybody, to the extent that is within my control, I want for everybody here to have a fair trial under the Constitution of the state of Georgia, the United States, and the laws of our state, okay? That is why I am here as a judge, to make sure that that happens. So to that extent, it's granted.
I appreciate that. I guess my concern is that all this is not under your control, because you're taking
And I can hear you fine, but I don't know whether my court reporter can or not. You can either come up or you can pick up your mic if you're just a long way away.
I guess my concern is that and I have no doubt that you will do everything in your powers. I just don't know if at this point, if it's within your control to ensure that we receive a constitutionally appropriate and fair trial at this point based on what's happened previously. And, you know, I do have cases regarding the concept of goading.
Okay.
But I'm trying not to step out of turn. I know that I am stepping out of turn a lot this morning, but I'm trying to not step out of turn. If you would like those cases.
Yeah, I'm happy to take into consideration anything that y'all want to offer that is on point.
Go. May I approach?
Yes. Can't really get to me, but you can get to my staff who can hand it to me. Thank you. Oh, yeah, I've seen web-cited, and I'll take a look at Jackson and Wilson.
Jackson. Oh, did I not give you Anderson?
No.
Oh, I'm sorry.
Thank you. Okay.
And, Your Honor, I believe that those cases stand for the general proposition combined. Each of them are a little factually different.
Okay.
But they stand for the proposition that the trier of fact can consider certain factors. Of course, the difficulty in determining if someone's goaded someone else comes down to intent. Typically, a district attorney or a prosecutor is not going to take the stand and say, I intentionally goaded someone. So you look at objective facts. And these cases stand for the proposition that you look at how basic the rule that was violated is, the experience of the prosecutor. In this particular case, you know, this is a big county. The prosecutors involved in this case are a chief deputy with the district attorney's office and a deputy with the district attorney's office are the two prosecutors that were involved in the ex parte meeting. You look at the evidence of the case, and I know that this is another area where you're hamstrung a bit because you haven't been sitting to hear the evidence. But I concur that the whole purpose of Mr. Copeland taking the stand was to impeach him. Mr. Copeland's testimony was not, well, at the time of this ex parte hearing, it's our stance that he was pleading the fifth, and the state was in a position that they're a key witness. And without him, the alleged murder of Donovan Thomas, without his past statements, goes away. And they were in a situation where their key witness was not taking a stand and was not going to allow himself to be impeached with prior statements. And our stance is that they panicked and they needed a mistrial. The trial was not going well. The previous witnesses that have testified, it's been again, I know you haven't been here, but you know, we've had witnesses testify. I don't remember anything that happened in 2013. It's just been a parade of impeachment by inconsistent statements and contradictions. So, and that's another factor that those cases look at is the how the trial's gone so far and the motivations for goading a mistrial. So I believe that those cases provide some insight and some guidance for the court to consider certain factors when we get to that goading question. And that's why I wanted to bring those to the court's attention.
All right, I appreciate it. Thank you. All right, so Mr. Harvey, you're up. I don't think there are any other motions for mistrial preceding yours that we have not discussed. And I am going to address a few of your issues really, well, I guess one I'm definitely going to address before you start your presentation, and that is that you assert in your motion that this court, meaning me taking over this case, has indicated it does not intend on familiarizing itself with the trial proceedings, and I have no idea where you got that from, because I certainly never said that.
When we were here last week, and I don't have a transcript of that, and if I've misinterpreted what you said, and perhaps it was in the context of you saying, I'm not going to revisit certain motions, or I'm not going to go back to hear those, that was in the context that I meant it. And I said it for a specific reason, because some of the motions, as I allege in our motion, Judge Glanville said, well, you know, I'm going to deny your motion, for example, for a severance, for a 105 instruction at this point, but that does not mean we're not going to get to a point where I would consider that and grant it. So I meant that in the context of you understanding, this court, understanding the cumulative nature of what has happened and how it would factor into your particular decision at the next point in trial. Does that,
that makes
is that
a
clear?
little more sense. I absolutely intend to familiarize myself with what has gone on in this trial prior to me getting involved in it. I've already begun to. Judge Glanville's court reporter is beginning the somewhat arduous task of transcribing everything that hasn't been transcribed yet and giving that to me, you know, as soon as she finishes it. You all have, some of you have already pointed out, you know, particular things that, while not the official transcript, I can review on YouTube, and I've done that to the extent it has been relevant to these motions. And I also believe that with the very capable defense attorneys in this case, that you all will be able to elucidate for me anything that I might not have been here present for at the point in time when you make a motion that to any extent requires considering the cumulative nature of anything. Okay?
Well, okay, yes, and okay, no. Okay, yes, I understand that the court is going to make what I think to be an impossible effort to catch up to where we are at this particular point after 9 months or thereabouts, hundreds of witnesses. I appreciate the court's effort, and I understand the genuineness of the court's statements that I'm going to do it, but you know what? I just don't think it's possible. And that is the gravamen, that's the base of what we contend should be a motion for mistrial qua mistrial. I have joined in we've been goaded into it, but now the second layer of that is I am going to stand here. My team is going to stand here. Everybody in this courtroom is going to stand here and look at you and say, Judge, the state, I want a directed verdict of acquittal. The state has not met their burden. I believe you have to be entirely conversant with the record, with the way witnesses have testified, their demeanor, their voice, their actions, all of which may or may not be caught on YouTube. And there are a plethora of cases. There are many cases that say, you know, just reading a dry transcript is insufficient. Every court from the U.S. Supreme Court down has said you can't necessarily make those kinds of judgments based upon a dry transcript. And I believe that to be true. There's a world of difference, and you know this. Every practicing lawyer knows this, that you cannot get the feel of a lawyer, you cannot get the context, you cannot get the understanding of a witness unless you're there to view that witness. So I start from the premise that no matter how hardworking you may be, and I think you're a very hardworking judge, I think that you will make every effort, but I think that it is impossible for when we get up and make our motions for directed verdict that you can assess the now going into the 9th month of trial testimony. That's essentially basis number one.
Okay.
More importantly, I think that should you erroneously deny our motions for directed verdict, that you then would be in a position to sit on our motions for new trial. And that's the so-called 13th juror. We have put that in our response, and it is without question. We have our courts, the federal courts, all say that there is a distinction between whether there is sufficient evidence to go forward, which is the standard on a motion for directed verdict, and a 13th juror motion for new trial. You can find, you know, I denied your motion for directed verdict, but you know what? I just don't think that this was either a fair trial or a trial in which, based upon what I have seen, what I observed, that should stand, and I'm going to grant it. I mean, it's entirely in your discretion. And that discretion is unreviewable, really, by the appellate courts. And they have all said, as we said and quoted in Wilkerson, that the discretion, the trial court must consider some of the things that she cannot when assessing the legal sufficiency of the evidence, including any conflicts in the evidence, the credibility of the witnesses, the weight of the evidence, meaning that the trial judge may grant a new trial on the general grounds, even when the evidence is legally sufficient to sustain a conviction. So I know that we're going to stand here and make a motion for directed verdict, that God forbid, if any of these defendants are convicted, we will come back to you and say, Judge, motion for new trial, sit as a 13th juror. Don't think you can possibly catch up to that extent. Nor do I think that, based upon the cumulative nature of Judge Glanville's saying, I heard you when you want a severance. I'm denying it now, but it may come to the point later that I'm going to grant it. So 3 reasons that nobody else has argued to you, essentially, for a motion for mistrial or a severance as to Mr. Nichols. 1, the motion for directed verdict. 2, the 13th juror. 3, the continuing nature of the motions to sever in for a Rule 105 instruction, a limiting instruction which the court said, you know, I'm probably going to give that at the end of the trial, but I don't think it's necessary to give it now. So,
Okay,
all of those.
I understand. And I don't really need to hear from the state on this one. With regard to the directed verdict issue, the standard, as we all know, is essentially an any evidence standard. It is entirely possible that just on what gets presented going forward, I will be able to rule on the motion for directed verdict, assuming we get there. But if not, I can and will ask for specifics from the state as to what the facts are supporting each count of this indictment. And it is not for directed verdict whether I'm convinced, it's whether there is any evidence from which a jury might be convinced. And so we'll take that up when we get to it, but I don't think that the fact that I'm coming in mid-trial is a basis to grant a mistrial in this case. With regard to the 13th juror, I understand that's a different standard. There are times, it's not routine, but it happens, when a different judge from the trial judge considers the motion for new trial and considers the 13th juror issue. And the appellate courts have recognized that it is a somewhat less deferential standard when they're looking at it on review, when it is a different judge than the trial judge. So, you know, if and when we get there, I will consider whether anything ought to be granted as a 13th juror, if y'all ask me that. And if I deny it, then the appellate courts can consider it. But that is not anything unprecedented. It happens all the time that one judge does the entirety of a trial and then another judge considers the 13th juror issue. So that is also not a basis on which to grant a mistrial. And with regard to the severance issue and the cumulative nature of that, I'm going to rely on you to point out to me everything ought to be taken into consideration if and when you make that motion again. With regard to a 105 limiting instruction, I am happy to consider anything that you all think might be appropriate to give right now. Okay, so I invite y'all to submit something. Okay.
To make sure that my motions were also based on the underpinning constitutional rights, both federal and state, and I don't want the appellate court to say, hey, she didn't say anything about that, but I want to make sure that those bases are preserved. Although I disagree strongly with your ruling, I'm still here.
All right, understood, and it is so noted, and obviously it's to whatever it is that you have, any of y'all have set forth in your various motions. All right. All right. I think we all already sort of agreed that we need to redo everything that happened post-recusal motion on June 12th and the Details and logistics of that we'll take up probably tomorrow. But that motion itself is granted. All right, a lot of what comes next is evidentially specific. And before we get to that, I know that there are some outstanding bond motions. So Mr. Steele, on behalf of Mr. Williams, has filed a motion for bond reconsideration, but Mr. Steele, you essentially go back and argue anew all of the factors that whichever, I don't even know who took up the bond to begin with, but another court has already considered all of those, the Ayala factors. And you don't present changed circumstances. You just essentially say this call was wrong to begin with and you should do it over. And I am not going to reconsider any bond issues that have already been considered and ruled upon by another court absent legitimate changed circumstances. So that motion is denied.
Can I address the court?
Do you have changed circumstances?
Yes.
So, okay, go ahead. There weren't any in your motion.
Mr. Williams has been in custody since the 9th day of May of 2022. This is in my motion. Or it should be in my motion. He has sat through unnecessary jury selection for months, bringing in over 2,000 people when the jurors were chosen from the first 511. That should not be on him. This is excess. He's now sat here for a month while the antics of Judge Glanville and Lawyer Love and Lawyer Hilton cause him to just wander and squalor in a jail. The case is, God forbid there's a conviction, going to be reversed potentially because these are serious issues, and I've raised them. I've put them to the court. There are issues of confrontation clause violations, prosecutorial misconduct, judicial misconduct, not being present at a critical stage of proceedings. There is no reason to believe that Mr. Williams is fleeing. He would be crazy, because if he flees, the case goes on because it's mid-trial, and he waives his appellate rights. He has the strongest ties to the community and the backing of wonderful people, both near and far, who are willing to come. Those are my changed circumstances.
All right. Thank you. I do not, they are changed circumstances from, yes, things happened after the bond was decided to begin with. I don't know how I would have decided the bond originally. That's not before me. Those are not the kind of changed circumstances that speak to the Ayala factors, and so I'm not going to reconsider the bond.
Well, let me ask one more then. There is a judge who joined the prosecution team. He said, we need a witness's testimony. He encouraged the witness, more than encouraged, to testify against Mr. Williams. I think that should come anew to the
All
court.
right, well, that may or may not be a substantive error in these trial proceedings. I've got that under advisement right now, but that also would not be an Ayala type change circumstance.
Okay.
So I appreciate you presenting this to me, but I'm not going to reconsider bond.
Okay. Even though potentially it was not done by a fair tribunal.
All right. There is nothing, and I'll make a determination with regard to that substantively, but I will note that Judge Krause, who had a lot of these issues before her in the motion to recuse, her finding, while I think dicta, was that there was nothing improper. She said, maybe I'd have done it differently, but that there was nothing improper substantively with what occurred. So at this point, we don't have, and the basis of her recusal was not that Judge Glanville is biased. It was that he engaged too vociferously in setting forth facts and information when he denied the motion to recuse, and that was not what the rules require, and so recusal was necessary. But she even, I think, went on to say, but even with that, I don't, I think he could have continued on unbiased. It's dicta, but right now, that is your position in the litigation. It's not a factual finding. It's substantively before me. And if that is the case, then there will be a different ruling made that will impact this trial, that may result in a mistrial, that may result in a mistrial with prejudice, but that would not impact a reconsideration of bond. Now, if there's a mistrial without prejudice, then bond maybe could be considered then. That might be a changed circumstance, but right now we don't have that.
Well, then I'd like you to address just one last thing then. Judge and district attorneys come out after that ex parte hearing and not a syllable about Brady evidence. It all should have been spilled right then. That's an ongoing concern. So my point is, you have the same judge denying bond, the same judge hiding Brady evidence. So I'd like you to consider that.
All right, thank you. I understand. It's not an appropriate consideration. I understand what you mean. All right, Mr. Huey has a motion for reconsideration of bond with asserted changed circumstances of the ex parte being a critical part of the trial that he was excluded from, and having been held longer than he otherwise would have because of the delay resulting from that. Do you have anything to add to that, Mr. Matthews?
Yes, Your Honor. Good day to this honorable court. Carrington Matthews for Mr. Marquavius Huey. I cite for the court Wimbush versus the state, 345 Georgia App 54, which is cited in my motion. When a court has previously heard a motion for bond, its ruling is not subject to change unless the court finds that the movement has presented new information, testimony, or evidence that indicates a change in circumstances. Wimbush, when it talks about new information, new testimony, or evidence that indicates a change in circumstances, I would like for the court to consider that the change in circumstances as it relates to this particular proceeding is that when the court denied the bond to Mr. Huey back in 2022, it determined that he did not meet the Ayala factors. This same court, in making that determination in 2022, the change in circumstances, the new information, the new evidence is that that same court that denied the bond in 22, that court indicated in or on June 10th, it had a meeting that this court has heard over and over again now with the state, right? With a sworn witness, right? And in the transcript, Your Honor, the court that denied the bond to Mr. Huey then, that court engaged in conduct which I believe influenced the witness, caused that witness to reconsider his position that he was not going to testify, talking about Copeland, caused that witness to, rather than say, I'll sit in jail, co-signed on the state of Georgia's recitation that, no, Mr. Copeland, you will sit in jail until every single defendant on this indictment is tried. So what I'm asking the court to do is look at what is the change in circumstance here. The change in circumstances, we want Mr. Huey. He wants an unbiased, a neutral referee to decide whether or not he is a good candidate for bond. I would assert to this court that that has been clouded because a neutral judge, a neutral referee would not have engaged in the conduct on June 10th, which essentially is why he has been recused. So I'm asking the court to say, hey, look, there has been new information, because that was not information that existed when the court decided that Mr. Huey was not a good bond candidate. That was not evidence when the court decided that he was not a good candidate. And we're looking at a judgment call here. The court has to be comfortable. The court has to be confident that when a request for a bond is made, that the candidate, based upon the change in circumstances, would be a good candidate for a bond. Now, Mr. Huey has been in custody since December 14th, 2021. It's a long time. Now, Judge, we have been out of court, out of session for over a month and some change and still counting. That delay, Your Honor, is a change in circumstance for Mr. Huey. He is on 23-1 at the Fulton County Jail. He's on lockup for 23 hours out of the day. 1 hour out. We don't have to go over and over what the conditions are at the Fulton County Jail. We know what they are. The news media shows us what they are. He tells me what they are. When I go visit him, I see what they are. So what I'm asking the court to do here is look at those change in circumstances. Now, here's another factor. How much, Your Honor, does it cost the taxpayers of Fulton County, Georgia, and the state of Georgia?
Mr. Matthews, that is not an appropriate consideration for bond.
I would ask.
Period.
Understood, Your Honor. I'm asking the court to look at the resources that are required to have Mr. Huey here every day. That's all I'm asking the court to look at.
Consideration for bond. All right.
So essentially, Your Honor, I'm asking the court to look at the change in circumstances that I have cited in my bond motion. I'm asking the court to take that into consideration, that the decision to deny the bond for Mr. Huey in 22 was made by the recused court, and the change in circumstances that I am alleging were done by the recused court.
All right.
Based on judgment calls.
Okay.
So, Judge, I'm asking the court to set a reasonable bond with conditions. Here's what I'm asking the court to do. Put a number on the bond. I'm asking the court for a $50,000 bond. I'm asking the court that Mr. Huey be required to live at a certain residence here in Fulton County, that he be required to have 24-hour house arrest on a monitor, right? He be required to only come to court and only meet with his attorney for the duration or the rest of the proceedings of this trial, if it gets that far. Obviously, to have no contact with any other co-defendants in the case, and for any other reasonable conditions that this court believe would be meet and proper. based upon our request. We believe in 2022 that the Ayala factors were met. The court has indicated, obviously, that the other court made that decision, and then this court wants to hear about the change in circumstances. I think I've efficiently been able to lay those out in our motion, support it with proper case law, and also I would, just for the record, I would address the case that I cited with respect to the ex parte meeting, and that's Scudder versus the state, 298 Georgia 438, a 2016 case.
What was that cite? Is it in your motion?
It was in my motion, Your Honor.
Okay.
And the Scudder court determined that a criminal defendant has the right to be present and to see and hear all critical parts of his trial,
Okay.
so forth and so on.
That's with regard to that substantive issue.
Yes, Your Honor.
Okay.
Which we are alleging is a change
Okay.
in circumstances, a change brought about by the court and not by Mr. Huey. And we believe that that month-and-a-half delay where he's had to sit in the jail, we're asking the court to not only be a court of law, but to be a court of equity, which this court is. And we believe that equity and fairness dictate that a reasonable bond be set in this case. Otherwise, any other change in circumstances that are not brought about by Mr. Huey has to suffer the consequence. And that's what he's doing. He's suffering the consequence, Your Honor.
Okay.
Respectfully.
Thank you.
Thank you, Judge.
All right. So that the record is clear, the basis for the recusal of Judge Glanville was not that he is biased, was not that the ex parte itself was improper. It was that Judge Glanville engaged in an exposition on the facts in making his rulings on the motions to recuse. I understand the argument that the court who undertook the original bond consideration, in the defense's view, has become biased, but that in the same way that I said to Mr. Steele with regard to Mr. Williams, if I substantively end up determining that, then it may be appropriate at that time to take up bond again. Right now, it is not. And it is unfortunate that this case has lasted as long as it has. It is unfortunate that there have been delays in the case, but those do not, in this court's mind, amount to the kind of changed circumstances that make it appropriate to reconsider bond. So I am not going to reconsider or grant bond in Mr. Huey's case either. Mr. Kendrick also has a motion to reconsider bond. He asserts changed circumstances that essentially this case has taken way too long, which
Well,
I
Your Honor,
don't
could I-
necessarily disagree with, but
I would ask you for Mr. Kendrick's bond motion, if you could defer ruling on that until after you rule on the mistrial.
all right, I will do that. I
Thank
think
you.
that would be more appropriate. Thank you. Okay. So the next thing I think that it would be appropriate for us to begin to undertake is some of the specific evidentiary motions. Mr. Stillwell has a motion for, it's entitled for reconsideration regarding certain hearsay statements, but given that we've all acknowledged we're redoing Mr. Copeland's testimony, it's not even really reconsideration, it's consider it anew as we go forward. So I'll hear you on that.
Thank you, Your Honor. Before I get started, could I hand over a case. It's actually the Scudder case that Mr.
Okay,
Matthews
sure.
referred to. And the reason I'm giving you this case, when you consider some of the issues that you said you're going to consider tonight, I never really, and I understand, I'm not complaining, but I never addressed my other motion, which may in fact not be a motion, but
For a fair trial?
yes.
Okay.
But in the state's argument against Mr. Kendrick's motion, they're relying on King.
Right.
I would invite the court to look at the facts surrounding this ex parte meeting. It's clearly distinguishable in every
Okay.
way from King when you look at the facts. And I would just remind the court that King was involving a request, giving the court background facts to show that granting immunity to a witness was in the interest of the public.
Okay.
That had already been done in this case the Friday before. So it's completely different when they had the ex parte meeting on Monday, and I believe Scudder is
Thank you.
more appropriate
All right.
to consider, and it's much more analogous and on point to what happened in this case. And of course, Scudder points out the problems with such a meeting and held that it was improper. Regarding this issue of Mr. Copeland's, I appreciate the court correcting my label of what this really is. I agree that it's a consideration anew, and we had prior discussions about it. There was not a written order to this point.
And do you want me to take a look at the original consideration? If so, y'all need to point me to where I would find it.
I don't know where it is,
Or we
and
can
this
just
is not.
start over.
I don't mean to sound like I'm being a smart aleck here. It was discussed. Some of my motions were brushed over so quickly. I think I assumed that I had lost that motion in front of the prior trial judge, and I'm not sure if there was actually a ruling or not. I'm trying to, if I could go back to my seat for a second. I just
Sure.
I'm gonna give you something else as well. Yep. Give you this one. Okay. I'm handing 5 cases to the court, and I've also provided copies to the state.
Okay.
Factually, what this is about, Your Honor, is based on statements made by Kenneth Copeland, out-of-court statements. I think the understanding where we are and the understanding of the facts as we know it, or the alleged facts as we know it, is that Mr. Copeland claims that he was in Mechanicsville on January 10th, 2015. This involves the alleged murder of Donovan Thomas, for which Mr. Stillwell and Mr. Kendrick are charged, and is part of this RICO indictment as well. He alleges he wakes up in the middle of the afternoon, is in Mechanicsville, maybe 300 yards from the scene of where Mr. Thomas was shot, at the Green Store, off of McDaniel Street, at the corner, I believe, of McDaniel and Glen Street. And Mr. Copeland tells the police that he is trying to find his friend Demekion Garlington, and trying to figure out where his friends are, because he woke up in the middle of the afternoon. And he allegedly calls Mr. Garlington and travels down to a McDonald's on Cleveland Avenue. In these pretrial statements, he claims that Mr. Garlington was pulling into the McDonald's as he was pulling in, and essentially in pretrial statements he says Mr. Garlington and a gentleman named Mr. Demise McMullen, who's also known as Nard and is also charged with the murder of Donovan Thomas, approached the car. Mr. Garlington gets in first, and quickly indicates to Mr. Copeland, before outside of the earshot of Mr. McMullen, they killed Nutt, essentially, and allegedly points to another car that is a white small SUV type car that contains, according to the story, Mr. Stillwell, Mr. Kendrick, I believe, Mr. Williams, Mr. McMullen was at one point in the car, and another gentleman. The point is, it's a quick statement, and it's they, and he points to this car, according to Mr. Copeland, out of court. And this was June 10th, 2015, when Mr. Copeland said that.
Yeah,
There were-
and I have listened to and read the transcript of that interview.
Okay,
So I'm familiar with it.
And just to add context, there were several interviews with Mr. Copeland prior,
Right.
and he never made mention
This
of
was
these
the
things.
fifth one.
So, and also to add context, Mr. Garlington is called in to an interview. He's subsequently interviewed. He denies making those statements. Also to add context, Mr. Copeland, on the stand, acknowledged that he made those statements to the police, but denies that they were true. And although he didn't specifically say it, he seemed to be alluding that he no longer has the same relationship with Mr. Garlington now as he had back then, because Mr. Garlington wouldn't lie for him. It wasn't directly said, and I'm sure will come up in cross, but putting the dots together, Mr. Copeland was in legal trouble, wanted Mr. Garlington to lie for him, to verify this lie that he was telling the police. Mr. Garlington wouldn't do it, and it foiled Mr. Copeland's attempts to get out of jail. That's the context behind all this. But the question is the admissibility of this statement, they killed Nutt, and to the extent any follow-up conversation about that incident that Mr. Garlington allegedly said to Mr. Copeland. Mr. Garlington is charged in this indictment. He has a Fifth Amendment right. He's not on trial with us. I have no information that suggests that he's going to be testifying in this case. So he will not be testifying. So the state is attempting essentially to ask Mr. Copeland about statements he made to the police of what Mr. Garlington told him, because there's no indication that Mr. Copeland himself has any firsthand knowledge or is a witness to any of this. Now, I have a separate concern about the way they're not laying the foundation for a prior inconsistent statement to play the videos, because Mr. Copeland is in fact acknowledging that he told the police. He's not denying making that statement, he's just denying the veracity of that statement. That being said, the statements themselves, how are they admissible? Because they're clearly hearsay. Garlington to Copeland. Copeland without firsthand knowledge. So the state has always taken the position, as I understand it, that these are statements by a co-conspirator. Mr. Could you grab my computer? Thank you. They've always taken the statement that they're statements by a co-conspirator. In their filings recently, and I don't want to misstate this, they may have made this claim before, so I'm not going to say it was the first time to make this claim, but I noticed in their filings, they argued in the alternative that they're statements against penal interest as well. And they've provided cases, and I have just handed up my cases. Regarding co-conspirator statements, of course, and we're talking about hearsay and the confrontation clause. There seems to me their main reliance is on the Kemp case, where the Kemp case, as they want it to be understood, is that idle chatter or narrative of past events do not further a conspiracy, but narrative of past events are admissible if they serve some present purpose of the conspiracy, including statements made to solicit membership or participate in the conspiracy or to promote cohesiveness among or provide reassurance to other conspirators. And the reason I filed this motion is because in all prior discussions, the trial court completely glazed over the furtherance. I'm focusing on whether these statements furthered the conspiracy. Okay. The state's cases do not apply to this situation. The difference, and I'm referring to the Kemp case, United States v. Flores, which the state relies, United States v. Santiago, and U.S. v. Holt, all in their filings. There's absolutely no indication in the record in these statements that the alleged declarant Garlington was attempting to solicit the membership of Copeland in the conspiracy in any way. And I understand the states, in the case law, some of the cases indicate this, that you have a conspiracy, you got a small conspiracy and a large conspiracy, and statements in furtherance of a conspiracy could be furthering the large conspiracy. Okay, but soliciting membership, there's been no allegations whatsoever by the state. In fact, we've been talking about this ex parte motion ex parte hearing where they're saying that Mr. Copeland clearly had nothing to do with the murder of Donovan Thomas. They've fought to say that Kenneth Copeland had nothing to do with that conspiracy. So there was no solicitation there's no evidence of anyone soliciting his membership in the conspiracy to murder Donovan Thomas. In fact, that had already occurred at the time that these alleged comments by Mr. Garlington were made. And if the argument is, well, they were trying to solicit his membership into a larger conspiracy, the YSL conspiracy as a whole, Mr. Copeland, according to the state, from the very beginning, according to their expert, Investigator Belknap, according to everything they've shown the jurors pictures of Mr. Copeland, videos of Mr. Copeland, from 2012, 2011, 2013, well before this date, where he's with these gentlemen, putting up hand signs, claiming YSL, all the rest. If the argument is, well, they were soliciting him into the larger conspiracy, he was already part of the larger conspiracy according to the state.
Okay, let me ask you this. So a part of the cases that the state cited, I mean, it may be that part of it was one way you can find this as a co-conspirator exception is soliciting membership, but another concept was to further the purposes of cohesion amongst, and I think they have gang cases, so a gang. So can you address that?
Well, they have the burden of proof by preponderance of evidence to show that this has been furthered. There's been no evidence. Again, we're seeing pictures from over the years. There appears to be complete cohesion. There's been no evidence that this was done, if it happened at all, which my stance is it didn't happen, but assuming that the statement was made by Mr. Garlington to Mr. Copeland, this brief statement, I think we're really stretching where the exception is essentially swallowing the rule. If we just say, well, a statement about past events with absolutely no indication that someone said, hey, this is what we need to do. We need to be quiet. We need to do this. We need to do that. There's no indication that Mr. Copeland was instructed to do anything. Mr. Copeland just drove where he wanted to go afterwards. Now, I will say, and I'm sure the state's going to point this out, that people on the street apparently thought Mr. Copeland was involved and began allegedly shooting up houses that he was associated with, but that has nothing to do with the purpose of the statement that allegedly Mr. Garlington made to Mr. Copeland. So there's absolutely, I mean, the record is just completely devoid of any evidence that supports that other than the statement themselves and just reading into the statement and just assuming, well, it must have been done for cohesion. But again, if we can just assume with nothing else, then what's the point of the rule to begin with? Mr. Copeland has never testified that anyone allegedly involved in the murder of Donovan Thomas has ever asked him to do anything. You know, the story that comes out through past statements are Mr. Treadwell takes a car somewhere to get rid of a car, to get rid of guns. You know, again, I'm not saying these are true statements, but that's what comes out in the discovery, and that's what comes out in other people's statements. Mr. Copeland has, it's completely devoid of anything that Mr. Copeland was asked to do. As far as also fostering cohesiveness, Mr. Copeland himself said that Mr. Garlington at the time was his best friend. So I'm not sure. In the United States v. Flores case, they talked about cohesiveness and cohesion within the group. And that was a situation where one individual, the declarant, was talking to another individual that didn't know. So you got the declarant, who ends up, and then another individual who ends up being the witness. We'll call him the third party. And then you have the defendant, and the declarant is telling the witness, hey, let me tell you about the defendant. He's a solid guy because this is what he did, and we're all one cohesive group. But the witness and the defendant were not close. They didn't really know each other. So the middleman, who ends up was the declarant, is kind of informing one person about the other and saying, oh, he's solid. We can be cohesive. In this case, Mr. Garlington and Mr. Copeland and Mr. Stillwell all knew each other very well, and that's come out in testimony. That they're, according to Mr. Copeland, they were the three best friends. So I don't understand how that falls under fostering cohesiveness, because there was already extreme cohesion between that group. So I think it's distinguishable in that aspect as well. US v. Holt, I'll just point out also, With all my other arguments, there's no indication in that case. It talks about keeping a co-conspirator abreast of the situation. There's no indication that Mr. Copeland needed to be kept abreast of the developments at the time. Mr. Copeland was not summoned to do anything by the group. Mr. Copeland called Mr. Garlington wanting to find out where he was. So it wasn't a situation where the group, assuming these statements were made, called Mr. Copeland to bring him in. Oh, can you pick us up? Can you do this? Mr. Copeland reached out to them. And also I'll point out that U.S. v. Holt was argued under or decided under the plain error standard because the trial attorney did not object appropriately. I have the 4 cases I handed up: U.S. v. Blakey. Well, I'm sure the court will read the cases, but State v. Wilkins I thought was particularly informative. It's a Georgia Supreme Court case. Trial court made a pretrial ruling excluding incriminating statements made by the co-defendant had been tried earlier. Trial court held that while statements were made by a co-conspirator, they did not further the conspiracy, and the trial court did not abuse its discretion. And it goes through all these different statements that the declarant co-defendant made that were basically spilling the beans and did not further the conspiracy in any way. State v. Lane, same thing. In that one, it's interesting. The appellate challenges the murder conviction, and the trial court granted Lane a new trial. The allegation was, the appellee, the defendant, hired Stallworth to kill a gentleman named Mr. Perez. A witness named Thompson testified that Stallworth told her about the plans to hit a lick before the killing, and then afterwards said that Lane did not pay him because he killed the wrong guy. The trial court initially at trial let the statement in, but then at the motion for new trial reversed itself, saying that in no way, in no stretch of the imagination was this statement made in furtherance of the conspiracy. A statement merely spilling the beans, disclosing the scheme, or informing the listener of the declarant's activities are not a statement in furtherance of the conspiracy. The state points to no evidence that suggests that by these statements, Stallworth was seeking to solicit the help in conducting the scheme or concealing its existence when he made those statements to his girlfriend. So those are the cases that I rely on. I also provided Stafford v. State, which is a little different because that was made to law enforcement. It supports my proposition generally, but it's a little different because it was made to law enforcement. Would you like me to address the statements against interest while I'm up here?
Is that in this motion?
Well, no, I understood the state's reasoning for the admission of these statements.
The penal interest? Yeah,
Yes.
Go ahead, yes.
So I'm confused on how this is against Mr. Garlington's penal interest to say they killed someone. It's a hearsay statement that inculpates the accused is admissible if the declarant is unavailable. Okay, I can see that. The statement so far tends to subject the declarant to criminal liability that a reasonable person...
Please read a little slower.
Gotcha. I'm sorry. That would subject the declarant to criminal liability that a reasonable person in his position would not have made the statement unless he believed it to be true, and the statement is corroborated by circumstances clearly indicating its trustworthiness. My main objection is number 2, although I do believe that the statement is not corroborated either. But prong 2, it was not the type of statement that tends to subject the declarant, in this case, Demekion Garlington, to criminal liability. He said they did it. I don't know how that could be a reasonable person could, how it could be said that a reasonable person would feel that saying they did it would put that person in legal jeopardy. As we know, as the pattern charges tell us, knowledge of a crime, mere presence, but certainly knowledge of a crime is not enough to convict anyone. And again, he did not say that he had any part in it. He did not say he played an active role. Additionally, Your Honor, I would point out the Williamson case that I provided. And the Williamson case is, I believe it stands for the proposition that when if you find any part of Mr. Garlington's statement to be self-inculpatory, which I don't believe it is, Williamson dealt with a situation where within a statement there's inculpatory and exculpatory segments of the declarant's statement. And Williamson says you have to deal with the pieces of the statement individually, and you just can't say, well, there is some inculpatory parts of this statement, so therefore it's all allowed in. You have to excise out the self-exculpatory areas within the statement and the neutral areas within the statement. It says 804B3 only extends to self-inculpatory statements and not self-exculpatory portions of a larger inculpatory statement or to aspects that are neutral as to interest. Self-exculpatory statements are exactly the ones which people are most likely to make when they are false, and mere proximity to other self-inculpatory statements does not increase the plausibility of the self-exculpatory statements. And for the record, that's Williamson v. State, 512 U.S. 594, 1994. So if there are, which I don't believe there are, any inculpatory parts of Mr. Garlington's statement, the exculpatory or neutral aspects of that statement need to be excised out. And I'll point out that if you listened, and I know Your Honor did listen, but I mean, I've listened to these statements 15 times, 20 times at this point. It's very unclear to me where the source of some of, we're assuming a lot of it's coming from Garlington, but it's really unclear where Mr. Copeland is claiming to have received some of his information and when he received some of his information. So that makes this task difficult. I think that absent a showing that the state can meet their burden under 801D2E or 804B3, that none of it should be admitted. But certainly, if we were going to admit some of it, we would have to excise out the parts that are not self-inculpatory, including, but not limited to, the part where he's pointing at other individuals and say they committed a crime. So those are my objections. I think if they come in, that it violates hearsay as well as the confrontation clause.
And what's your confrontation clause argument? Because we haven't really touched on that so much.
Mr. Garlington's the source of the information, and he's not going to be subject to cross-examination. He's not testifying.
All right.
So thank you.
Thank you. Who's arguing this for the state?
I am, Your Honor. Judge, I will, of course, stand on, not stand only on, but stand on the response that we have filed. I would point the court's attention, starting off to page 3 of our response. and the second full paragraph on that page, Your Honor, where we are giving some facts of the case wherein it's already been shown at trial that a few days before the murder of Mr. Thomas, Mr. Copeland said that he was with Defendant Williams when Defendant Williams rented an Infiniti from a rental facility at the Atlanta airport. That same Infiniti, we allege, was utilized in the murder. Evidence at trial has already proven that Defendant Williams did in fact rent an Infiniti Q50 on January the 7th and returned it on January the 11th. Testimony at trial has already revealed Mr. Thomas's participation in Mr. Thomas's standing as a high-ranking rival Inglewood family blood gang member to the YSL criminal street gang. The week before, as Mr. Thomas was murdered, Mr. Copeland was physically assaulted at Club Crucial by Mr. Thomas's brother, Kelvin Watts. And in the early morning hours after the murder, multiple YSL gang members, including Mr. Copeland.
Slow down.
I apologize. Including.
And y'all start reading instead of talking. Speed up. All right, go ahead. So in
the early morning hours after the murder of Mr. Thomas, multiple YSL gang members, including Mr. Copeland, Defendant Williams, Mr. McMullen, Demekion Garlington, Diamante Kendricks, and Shannon Stillwell fled to Miami, Florida. And after these members of YSL returned to Atlanta, there were a number of retaliatory shootings between YSL and IF gang members. So just to sort of encapsulate that, all of that, when Demekion Garlington alerted Kenneth Copeland that they just killed Nut, he was alerting Kenneth Copeland to the fact that a rival, a high-ranking rival gang member, has just been killed by our guys. And it's important for us to now prepare, protect ourselves, and flee to Miami.
Excuse me, I apologize.
yes, sir.
A lot of this is not, and I put in writing, I'm objecting to any proffer of Ms. Love. A lot of this is her theory. It is not what the evidence has shown or will show.
Okay. So you, Ms. Love, are presenting this as what the evidence has already shown.
Part of it. Not
So-
the part that I'm saying now, I specifically say when I mean to say that the evidence has shown.
Okay, so the evidence has shown that Thomas was a high-ranking
Yes.
person in a rival gang.
Yes.
That the week before Mr. Copeland was assaulted by Thomas's brother,
Yes.
that in the early morning hours after the murder, Mr. Copeland was amongst the people who fled, the group of alleged YSL members who fled to Miami. That's established already?
No. So that will be established.
Okay.
I did not assert that testimony at trial has revealed this, but I am
Okay.
asserting that it will be established.
And Your Honor,
Who all has,
I apologize. If it matters, it was not in the early morning hours. Mr. Copeland's phone records, if you go by phone records, will be several days later.
Okay. Thank you.
Excuse me, Your Honor, I object to the language of it's already been proven in here. I don't mind if she says that there's been evidence that's been submitted, but
Okay.
already been proven, I think, is too much.
Noted. Agreed. That's not for us to decide. That's for the jury to decide. Ms. Love.
our position.
That's fine. Our position is fine. But what, so is your evidence going to show that Mr. Copeland went to Miami in the early morning hours after the murder, or is it going to show that several days later? he
Not
went to
several
Miami?
days later. I believe it was actually, I know that, was it the next day? I think it was the next day that
The murder was,
January 10th.
okay, and he went to Miami.
And then he was in Miami.
While the state's doing that, if you really care, it's
Your Honor, if I
January
may.
6th is the alleged beatdown.
Okay.
Mr. Copeland, it wasn't a week earlier. January 10th, it's going to be January 6th. It's at the club
Okay.
compound.
Thank you.
Crucial, I say compound, not crucial.
It was the Sunday before, Your Honor.
Okay.
And so the murder is January 10th in the evening. Some YSL members arrived in Miami on the 11th. Mr. Copeland arrived in Miami on the 12th. So the departure from Atlanta by some was hours after
Okay.
the murder. Mr. Copeland gets there on the 12th.
Okay, and do you have evidence that they all congregate together?
Yes.
In Miami? Okay. Okay, and does he go, does your evidence show that he is with anybody else on his trip to Miami? I'm just curious.
Just 1 second.
Testified to answer your question. I believe that Mr. Copeland testified after the recusal motion, that he traveled to Miami with his girlfriend or the mother of his child
Okay.
and his baby.
All right, thanks.
And also, my understanding, and I believe it was testified to, it may not have been, was just to, when we're using the word fled, is that Mr. Williams had a show in Miami.
Okay.
So, Your Honor, Mr. Copeland, I believe, has testified already that they were collectively in Miami.
Okay.
Regarding the court-specific question of who he went down there with. We don't
That's
assert
okay.
who he
They were
specifically went down there with.
Together once down there. And when did they come back?
They came back at different times. Our phone records, I'd have to look at this.
Couple of days later? I mean, just give me a ballpark.
Some, they came back at different times.
Okay.
Different times.
All right. And was there a show for Mr. Williams down there? Some kind of a music show, I assume?
That's an assertion
Okay.
that we haven't, that's not evidence that we
Okay,
have or we have put in. That's not evidence that we have.
All right. Well, that might be some.
And there was, so just to also clarify, this vehicle that was rented, it was rented for a certain number of days. It was
Okay.
supposed to be returned, I believe, 3 days after it was returned. So they returned it early. They returned it on the 11th instead of returning it later in the month as it were. I think, as I said earlier, I believe it was returned about 3 days early. If there was a show, Mr. Williams was aware that he was going to be attending at a particular time on the 11th, the need to keep the car, unless they intended to drive the car to Miami, I would assert, should have reflected itself in the way that he secured the rental. If he intended to be at a show, then
All right. What date did he rent it?
he rented the Infinity on January the 7th, I believe it was. And he returned it on the 11th.
All right.
And the already admitted at trial is the rental agreement that shows that it was due to be returned later after the 11th.
So it was probably a week rental,
Actually, Judge,
maybe? Okay, whatever. You said a few days early, which, okay. All right, so back in the Atlanta area, there is a series of retaliatory shootings. Is that in evidence, or is it going to be in
that
evidence?
has been already put in evidence
Okay.
and additional information regarding those.
And is there any evidence that Mr. Copeland was involved in any of those shootings?
Yes.
Back and forth, okay. Between YSL and whatever the gang is
If
that
gang.
Mr. Thomas,
IF,
okay,
yes.
all right.
Specifically, if I may, there were instances that were testified about regarding a particular shooting. So right after the murder of Mr. Thomas, there were a number of shootings that Mr. Copeland was very concerned about and spoke about when he spoke to police in the early morning hours of the 11th. When he himself went down there, he essentially said to them, and I believe that the court has the recording of Mr. Copeland's first interview, they're shooting at me. They think I did it. They being Ifke, they think I did it. And so his girlfriend's father's house was shot up. His brother's house was shot up. Mr. Williams's father or stepfather's house was shot up. There were a number of shootings that have already been testified about.
All right. All right.
So just to start with the assertion regarding cohesiveness, that it's not so much a situation where we're asserting that someone is trying to bring Mr. Copeland in to the fold. He's already a part of it. And in alerting him to this happening, this event, he's including Mr. Copeland in on what's going on with the gang. This is our position, so that Mr. Copeland can comport himself appropriately.
All right.
We have noted in our response that when we are talking about a conspiracy, it's not just the conspiracy, it's not regarding the conspiracy of the murder of Donovan Thomas only. The conspiracy is the wider, broader participation in YSL, and the criminal conspiracy is alleged in count 1.
And Ms. Love, is it correct that Mr. Copeland also said to police that after the first revelation that they shot Nutt by Mr. Garlington, that, and that was in the McDonald's parking lot, that either they did or they were then instructed to follow
They did follow them.
the car that had apparently been involved or allegedly been involved, follow that car to
Condo.
another place where they all spent the night,
Hold on just 1 second.
and that he did so?
Okay. We're trying to make certain that the court is hearing that it's Mr. Treadwell's vehicle, not the Infiniti,
Okay,
that they are following to the same place.
okay. But the vehicle that Garlington apparently indicates when he says they shot Nutt
Pointed to the
means the people in that car.
Yeah, the Nitro, yes.
Nitro, okay,
Yes, the
sorry.
Dodge Nitro.
Okay. And they then,
Followed the Dodge Nitro.
Mr. Copeland follows the Nitro.
Yes.
And is he directed to, according to him?
I don't know that he says that he's
Okay, well, anyway, he follows the Nitro and they all spend the night together at an apartment that Mr. Williams has in Midtown?
I don't know that they spend the night. They end up at Mr. Williams.
I don't know whether they did either. I'm asking what Mr. Copeland said happened.
That they all go to the
Okay.
home of
Okay.
Mr. Williams.
Okay.
I can assert what I expect other evidence will show that is not yet been shown, but other persons that we expect will testify during the course of this trial will also say that they met at Defendant Williams' condo, and as reflected in some of the factual acknowledgments of some of the persons who have already entered negotiated pleas in this case, they were given money to lay low. Members of YSL were given money to lay low following the shooting of Mr. Thomas.
Okay. All right, and so your theory is that...
In alerting
Go ahead.
Mr. Copeland to what just took place, it furthers cohesiveness. It lets him know about a significant event that just took place that involves members of the gang itself that he needs to be aware of. He needs to be alerted to so that he can act accordingly.
All right.
And they do act accordingly.
Okay. All right, what about your statement against penal interest argument? I mean, I think that Mr. Sharp raises kind of a good point that how can it be against Mr. Garlington's penal interest to say somebody else did the shooting?
It wasn't just the shooting. He also, Mr. Copeland, that is, also talked about Mr. Garlington's words to him regarding his presence and his knowledge of who it was that participated in the Little Wayne bus shooting as well.
Okay, so this is an entirely different shooting.
There were two, yes. Two
Right,
different ones.
so let's focus right now on what he said, the hearsay about the Thomas shooting.
Okay.
How is that against Mr. Garlington's penal interest?
It's, Mr. Garlington, as we said, is providing information about we argue, a gang-motivated crime committed by members of the same gang that he is a member of. So in saying what he did, he is talking about actions committed by, I would argue, co-conspirators. He is a member of the same criminal conspiracy as those that he's called murderers and shooters in the Little Wayne incident. He is, given the context of his relationship, his being Garlington's relationship with Stillwell and the other YSL associates that he names as having killed Mr. Thomas, he had no reason to lie about the murder or the shooting. He would not be privy to the information that they just killed Nut had he not been a part of that same gang that these persons that he alleged have just killed Nut are also parts of.
All right, so is your theory then that when he says this, it reveals that he's a part of this same gang and therefore he can be charged under a gang count?
No, he has because of his involvement. So it's not just that, it's not so much that he can be charged under a gang count.
A statement against penal interest would require that what you say could get you arrested and convicted of a crime, right?
Correct.
So how is what he said going to do that?
It is evidence of his membership in a criminal conspiracy that is YSL. The act that they have committed is evidence that this enterprise commits criminal acts. It subjects him to punishment under count 1 in our indictment.
So as a RICO charge, not even a gang charge, RICO charge.
A RICO charge and a gang charge, to be clear, because in our case, the RICO charge is involving the criminal enterprise that is YSL, the criminal street gang. Mr. Garlington is a member of YSL, the criminal street gang. Part of what is necessary to prove a criminal street gang even exists is the fact that members commit crimes to further the interests of the gang. He is acknowledging that a group that he is a member of commits these type of crimes that he is talking about. That acknowledgement can subject him to punishment for acts that he commits as part of or in furtherance of the
Yes,
criminal
for acts
street
that
gang.
he commits. He hasn't, by this particular statement, admitted to committing any acts, right? He's saying somebody else did. All right,
As it relates to the shooting, he didn't do that.
okay,
Yes.
all right. Okay, anything else on this issue?
Just 1 second, Your Honor. And Your Honor, the fact that Mr. Garlington is alleged to have been, according to the statement, with them when they drove by and saw Mr. Thomas before the murder.
Okay.
Also reflects his involvement in the gang itself.
Okay. All right. Sure.
And Judge, if I
Hang
may,
on,
before
she might
Mr.
not be done. Go ahead.
Apologize.
That's okay.
I would cite the court to United States versus Padilla, P-A-D.
Is this a new case that's not in your response?
It's
Okay.
not.
Okay, all right. US v. Padilla?
Yes.
What's the site?
It is 2000 U.S. APP Lexus 1843 at
At what?
5, page 5.
Okay. All right, 2000 US APP Lexus 1843 at 5?
Yes.
Okay. All right.
Wherein the court says that we reject the arguments of Padilla and Rodriguez that the district court erred in admitting plea allocutions of 5 co-defendants. The district court found that all of the co-defendant statements being admitted into evidence were self-inculpatory, involving inter alia admissions of membership in the named RICO conspiracy, and the court declined to reverse the district court's finding as an abuse of discretion. So in his statements, we would argue inculpate him in the RICO conspiracy that we have alleged in this case.
Okay. Thank you. Mr. Sharp.
John, I think it's clear that this is not a statement against penal interest. You know, it's what a reasonable person would believe. And, you know, to come up with these theories about RICO conspiracies when you haven't done anything wrong, I just don't see that as falling under that exception to the hearsay rule. Regarding the statements, whether they're in furtherance, you asked, was he directed? The answer is no. He called Mr. Garlington. Mr. Garlington said, hey, and this is before making any statements about the alleged murder. Apparently, he said, you know, can you come pick me up? Sure. He went down there. A statement, we say it was never made. Mr. Copeland now says it was never made. But regardless, the statement, if it was made once Mr. Copeland gets down there. He's never directed to do anything. He just goes and follows people that he knows. Okay. The state is arguing that narrative events given so someone can comport themselves appropriately makes a statement in furtherance of conspiracy. And if we just logically think about that, that would mean that any time there's a declarant and someone else and a witness who are allegedly involved in the same conspiracy or in the same gang or anything else, anytime a statement of a narrative events is made from declarant to witness and they're linked together in any sort of alleged gang or conspiracy, by definition, it would fall under this exception. And that's just not the case. The state is saying so he could comport himself appropriately. They have no evidence of that at all. That's just their theory, and it's just a blanket statement to say that it fits under these cases, but it's not backed up by anything. And you know, if we were to just allow those spilling the beans statements in under that just imagined alleged basis, then the rule really doesn't even need to exist, and the exception would swallow the rule. So it doesn't fall under either of the exceptions asserted by the state.
All right, thank you.
Your Honor, may I add one thing briefly?
Yes.
I just point out that the cases that were cited by defense in support for their position, those were not gang cases. Ours specifically, the cases that we cite are gang cases. We cite a plethora of gang cases. And in doing so, we express how here there is a distinction between the case that we have and the cases that they are citing, and that we are specifically talking about the criminal conspiracy of the YSL street gang. The argument that any statement made for a narrative purpose would be admissible is inapplicable here, where the statement that was made was not just any statement for a narrative purpose. It was a statement about a criminal act committed by a co-gang member, a co-YSL member or members of the enterprise that this young man, Damikion Garlington, is alleged by the state and we believe can be proven to also be a member of. Additionally, we will be at trial later on presenting evidence from other sources of what took place at that condo, which further show what we are arguing here.
All right. Let's break for lunch. We're probably a little bit on the late side for breaking for lunch, but it is 12:35. Let's come back at 1:45. Mr. Steele, I'm going to give you your copy of that transcript back. Thank you for loaning it to me. Thanks. The next evidentiary motion is Mr. Williams has filed a motion, and again, I don't know whether this is styled for reconsideration or what, but it's an issue we're going to have to deal with going forward. So while I'm not reconsidering prior rulings, we do have to sort out how we're going to handle this moving forward, and that is concerning 801 and self-serving statements. So, Mr. Steele.
There's been a lot of objections. Can't change the past. I've objected to it all. Over objection, I've been prevented from trying the case and putting on evidence based upon this so-called self-serving statement. My understanding, Your Honor, is that that changed with the new evidence code, and I cited for the court in my motion that I filed on, Attorney Adams, and I filed on July 10, 2024, some cases, and I might have attached the cases actually to the motion. I can't remember now. Walker, W-A-L-K-E-R versus State, 306 Georgia, at page 44.
Can you give me just
Of course.
1 second? I'm
Of
sorry.
course. It's okay. No apology, Your Honor. So, Walker is W-A-L-K-E-R versus State, and it's 306 Georgia 44, specifically footnote 3, 829 Southeast 2D 121 2019 case, where our highest court wrote that and I'm quoting now, the blanket policy against self-serving statements might not have survived the passage of the Georgia New Evidence Code. Then in Jones versus State, it's 303 Georgia, 496, it's in Division 4, 813 Southeast 2D 360 2018. That case is a pre-January 1, 2013 trial. So the self-serving statement objection was valid. So that's why I put that case in the motion. And then it's a good case of Hodges, which it's State actually versus Hodges, H-O-D-G-E-S, 291-413, footnote 6, 728 Southeast 2D 582 2012. Obviously that's before January 1, 2013. But what happened was our Supreme Court said that the new evidence code has indoctrinated or codified, I guess, OCGA section 24-8-801C, and that the new evidence code would not retain the self-serving statement rule. And instead, the court looks at relevance 401, 402, and then obviously 403 is for everything. In federal courts, United States versus Jackson, J-C-K-S-O-N, 780F2D, 1305, it's 7th Circuit, 1986. For over 40 years, self-serving rule was not followed in federal courts. And here, what was happening is anything said by Mr. Williams that I tried to get in on cross-examination would be met with an objection that was sustained as self-serving statements. At times, the recused Judge Glanville would allow it in under the rule of completeness, so 106, and 822, or 24-1-106 and 24-1-822. There were times that he let in, but self-serving statements were excluded even though they weren't going to innocence, which under the old rule, self-serving statement has to go to innocence. That's why it's self-serving. But anyway, I'm not saying that it's ever going to come up, but it happens so frequently. I just wanted to be courteous because that's the way it was going for several months in the court. So I just wanted to raise that to your attention. That's really what it is. In paragraph 11 of that motion, Your Honor, there was not as much, but under, I think it's 24-8-801, you got, I'm looking, my computer, 2B, I'm not sure that's right, but I think it's 2B. It deals with a statement that's adopted. So Judge Glanville would allow in, well, this was sent on social media and your client didn't respond. Oh no, that's not accurate. Or there was an alleged meeting and your client was there and he didn't deny it. Or somebody else had a lyric in a musical song and your client didn't come back with the next verse and say, oh no, that doesn't apply. And that's not an adoption has to be specifically intended to adopt by your silence. Like, so anyway, those are my issues.
Okay.
They came up a lot. I'm not, Your Honor, I am not saying that there'll be issues going forward, but it like permeated this trial.
Okay, I appreciate you bringing all of that to my attention. And I mean, this isn't really, I guess this is more bringing it to my attention than anything else. We're not talking about anything specifically right now. And obviously, as we're moving forward, we'll take up specifics of things as, I'm going to say as we get to them, although if there's evidence that either side knows they're going to be intending to use that might have issues or objections, let's try to deal with that to the extent we can before we're in front of the jury. I think I said that already. But, you know, I looked at all your case law and I've looked at the statute, and I don't know whether maybe some people were just using self-serving as sort of shorthand for something. I don't know, but I agree that there is not that's really no longer the issue. And if something is going to be excluded, it's not going to be on the basis that it's self-serving. It's going to be on the basis that it's hearsay and there's no recognized codified exception that has been met. So, I mean, that'll be my intention going forward is, you know, to look and see, is it hearsay? And then if it is, and obviously a prior statement of your client is probably going to be hearsay unless and until he testifies. So the question is going to be, does it come in under an exception? Is it a prior consistent or a prior inconsistent statement? And with regard to adoptive admissions as well, I agree. There has to be something to indicate, not just I heard it and I didn't say no. It has to be I heard it and I didn't in some way dispute it when the circumstances would expect me to dispute it. So yeah, generally speaking, that's my understanding. And like I say, we'll take up the specifics as they come at us.
Thank you, Your Honor.
All right.
That was the totality of that motion.
Great. Thank you.
This is left, can I ask a question?
Yes.
There's I don't know, I don't want to take something, but there's a transcript of the January 10th, 2024. That's yours?
Yeah. I think I handed yours back to you before.
Okay.
So I handed, or through my staff attorney, handed you back your copy. I don't know what that is. Okay, understood. All right. The state has a motion to exclude victim character evidence. It was filed on July 23rd, and I don't know if that's something that has been ruled on previously or what this one is really. Has that already been dealt with, or where are we on that?
It has come up, Your Honor, ADA action on behalf of the state. The state wanted to file that per the court's guidance of any motions where we were going through specifically Mr. Copeland's redactions.
Okay.
And there was a couple times, and Judge Glanville overruled the state's objection. We wanted some what we classified as speculative homicides that the deceased victim, Mr. Thomas, was involved in, that Mr. Copeland speaks about in his interviews.
Okay.
And so those redaction conversations with the court were after June 12th. So the state, foreseeing and forecasting at least that specific issue and or additional questions that may come up, wanted to file this motion precluding improper victim character
Okay.
evidence, Your Honor.
And flesh it out a little bit more for me.
Yes, Your Honor.
So Mr. Copeland wanted to testify to, and or you all had prior statements where he had mentioned and you wanted to get in him saying something about homicides that Mr. Thomas had been involved in perpetrating?
So, Your Honor,
potentially?
Yes, Your Honor. And I have some, let me grab these notes right here.
Okay.
Oh, no. I wanted to show these examples that I have. So, Your Honor, I printed some examples where Mr.
Okay.
Copeland, this was what the state wanted to keep out. So,
Wanted to keep out.
yes, Your Honor.
Okay.
And the way that the Honorable Chief Judge Glanville addressed these redactions was, state, let me know what you're not playing, and
Right.
then defense counsel would bring up questions they were going to ask Mr. Copeland and or play. So there was portions the state was not going to play and defense counsel said they wanted to get into, where
Okay.
Mr. Copeland is mentioning there's a murder on Auburn Avenue, there's an individual by the name of Scooter, and it comes up kind of off the cuff of he heard that Nutt had something to do with this murder. And so the state felt that that falls under what's kind of classically a specific bad act of a victim, which can't come in under really any witness to include a deceased victim in a case. And the case law and the state's motion on that is, explains all of that, I feel like, succinctly. And so the state, knowing that we're going to have to go back over these interviews with Mr. Copeland,
Okay.
and some of this may depend on the questions asked and his responses, the state filed this motion. There may be other instances. Those are what came to mind because we recently addressed those. And they're in a recorded statement of Mr. Copeland that the state did not want to play, but defense counsel wanted to ask Mr. Copeland about and or play it if it was impeachment.
Under what basis, if y'all had gotten that far, and maybe it's more fair to ask the defense.
I was
under
gonna
what
say that, Your
basis,
Honor.
But,
I will defer to the defense on their basis for that because I don't want to misspeak
Okay.
for them.
all right. Somebody from the defense want to let me know what they might intend to argue with regard to this type of evidence?
Couple things. First of all, regarding Mr. Thomas's character in general, the state, and I defer to the recordings. I don't have it in front of me. I'm not intentionally misspeaking. My recollection is Miss Love indicated on January 10, 2015, Mr. Thomas was just hanging out, on the street with his good friends, having a good time and, just having a friendly time. And then these mean guys did this thing to him, which was misleading. But then the state presented witnesses that said that Mr. Thomas was a gang member. This wasn't us. We didn't bring this up. That he is a gang member, that he was a gang leader. And then they brought in experts that talked about If Gang, Inglewood Family Gang, and Bird Gang. And these are the gangs that Mr. Thomas was associated with. And so all this character evidence has really come from the state's witnesses, and it's been elicited by the state. Now, regarding what Mr. Atkins just spoke of, I think we're putting the cart a little bit before the horse, because these are things that Mr. Copeland said in out-of-court statements. I am not conceding. I hope Your Honor is considering the prior argument today about whether the statements regarding what Mr. Garlington said Mr. Garlington's statements, alleged statements to Mr. Copeland, are even admissible. But then there's another issue. Even if they were admissible, our stance is that Mr. Copeland on the stand, and assuming he testifies consistent again, would not deny making those statements. So I don't even know why we're playing prior statements to begin with. All that being said, my recollection of the arguments were that Mr. Copeland was making references to what he knew about Mr. Thomas as, you know, a gang leader that may have been involved in other violent acts. My recollection of the litigation of that issue was that certain defendants, and it wasn't on behalf of Mr. Stillwell, but certain defendants have argued that Mr. Copeland is responsible for the death of Mr. Thomas. And the argument, as I recall it, was that if that's the defense's theory, that Mr. Copeland's belief and understanding, you got to remember in context, Mr. Copeland, aside from all the gentlemen here, was embroiled in his side controversy with Mr. Thomas's brother, Mr. Watts, Kelvin Watts. And there was a fight a couple days beforehand at Club Crucial where Mr. Copeland's face was blooded and he was robbed, essentially.
Right.
So he had this side disagreement going on with these individuals, and my recollection of the argument was that Mr. Copeland's knowledge and belief that Mr. Thomas had a history of violence created the motive to essentially a preemptive strike. That he knew that he was in a beef, in a disagreement with dangerous people, and that goes to his motive.
Okay, he's not.
Mr. Copeland.
Yeah, who is not alleged to have had, by anybody, as far as I can tell from what y'all have said to me today, to have had involvement in Mr. Thomas's murder before the fact.
I don't know. That's not been the state's theory, and that has not been Mr. Stillwell's theory. But that did come up.
Okay, well, it may be that what Mr. Copeland thinks about Mr. Thomas's violent reputation is entirely irrelevant then.
It may be irrelevant. You know, I don't want to speak for other counsel, but that's my recollection of the events. But again, I think that, in my personal opinion, the most prudent thing is to figure out which of these statements are even going to be admissible first.
Yeah.
But in general, Your Honor, the defense is not, you know, we haven't been bringing out evidence about Mr. Thomas. You know, the state played a video where Mr. Thomas's brother was carrying an assault weapon in the barber shop at the time of the shooting. The state's witness said that Mr. Thomas had a gun and was shooting back at whomever shot at him on January 10, 2015. That's all come from the state's witnesses and it's been elicited through direct examination. It hasn't come from us.
Okay.
Your Honor?
Yes.
I wanted to briefly, if the court would permit, I found my notes just to give the court some examples.
Sure.
So these are from my notes, so the time hack should be pretty close. But for example, in the January 28, 2015 interview of Mr. Copeland at Atlanta Police Department headquarters, right around 7:48:13, which is the time that evidence reviewer uses, Detective Dennis asked, "What do you know about Nutt having anyone else out there?" I might have missed a word, either killed. There was some alluding to that. And Copeland, I have, says, "On Cleveland, don't know much about it. What about the boy on Auburn?" And Copeland says, "Who? Scooter?" And Detective Gaither, another APD gang detective, says, "Mr. Copeland, you know, tell us more." You start smiling. And Copeland says, "I heard something, but was not much. It's just like he did get caught up. Somebody had him killed." So it's that kind of, in the state's opinion, speculative examples of specific conduct. And that's why in the state's brief that I know the court has reviewed these briefings, a April 2024 Supreme Court of Georgia case, Ward v. State, 318 GA 884. I used in Ward, it's dealing with kind of the outer limits when someone's claiming self-defense. I like reading Ward, one, because it's the highest court in Georgia and it's recent, but number two, not being able to use specific acts of the victim as character evidence in even a self-defense allegation, which no defendant in this case has alleged that they shot Mr. Thomas in self-defense, it still establishes it must be through reputation and opinion only. And so the state's it's a two-part motion specifically. Character of the victim is rarely relevant in a murder trial. And two, if it is relevant, it has to be through reputation or opinion on some salient issue. And three, what Mr. Copeland's discussing about, to the state's understanding, is quite speculative even at that. But the state's position is specific bad acts, which murder, I can't think of a more concrete example of a specific bad act of a witness or a deceased victim than murder. So speculating about that, the state feels that's just classic improper under 24-4-404 and 24-4-405 alpha.
Okay, well, I plan to follow 24-4-404 and 405. That's about as much as I can say about that right now until we get into specifics either. All right. But thank you for at least fleshing it out so I understand what we're talking about. All right, the state has a motion to compel defendants' compliance with the reciprocal discovery obligations and to exclude evidence intentionally withheld and not timely disclosed. And I had via email asked specifically as to the authorship of this particular motion and to have whomever authored this motion be present in court. The response I got back was Ms. Love saying, I will be present. Does that mean, Ms. Love, that you are the author of this motion?
Yes, Judge.
Okay. So I have some problems with some of the representations made in this motion. Specifically on page 3, the citation to U.S. versus Young, and then to U.S. versus Waddell, and then the statement, quote, a defendant has a duty, underlined, to disclose prior to trial and an ongoing duty to timely disclose, in bold, any evidence he intends to use as both impeachment evidence and as substantive evidence of innocence. See id, meaning see the above two cases, Waddell and Young. I've read both of those cases. Show me in either of those cases where there is a proposition that discovery and reciprocal discovery obligations of the defense applies to evidence that's going to be used solely as impeachment.
I didn't say solely as impeachment. I said as both impeachment and as substantive evidence.
Which implies that the use of it as impeachment evidence triggers the reciprocal discovery obligation.
No, unless I wrote it inartfully. What I was saying.
Well, you wrote it inartfully.
I did then, because what I was saying was that it has to be both. That is the representation that
all right.
I made. And then when I amended it.
I didn't see an amendment.
I have a copy for the court.
Did you fix that?
What I did was.
Thank you.
Sort of elaborate on it, or yes, I guess you could say it was fixed.
So you concede then that if evidence is going to be used solely as impeachment evidence, that there's no triggering of a reciprocal discovery obligation?
Yes, that's
okay.
Yes, I was not saying that.
Oh,
I was saying.
Good to know.
My apologies to the court for that inartful wording.
Okay.
And what I said in the amendment, Your Honor, was.
Did you email the amendment to my chambers?
I did.
Okay.
Yesterday, I did.
Yesterday. Okay.
Yes,
well, that may be why I hadn't seen it, although I've been looking at y'all's stuff nonstop.
Yes.
Okay. It's in front of me now, so.
So what our position is, Your Honor, as I state on page 3 of the amendment, is outlining what Georgia's statutory requirements are. Of course, the court is aware of what OCGA 1716 4C1 requires. Then I go down to subsection C on that same page where I cite Aggie versus the state 311 Georgia 340 at 343 and go on to say Georgia's discovery law does not explicitly apply 1716 4C to evidence used simply for the purpose of impeachment.
Okay.
And then I say it unquestionably applies to that second intended purpose, use as substantive evidence. And then in section D, Your Honor, I cite two relevant similar federal laws, pointing out that federal law requires the defense to provide the government with materials that are within the defendant's possession, custody, or control.
Excuse me, counsel, slow down. Possession or control.
Possession, custody, or control. My apologies. Where the defendant intends to use the item in the defendant's case in chief at trial. And that's Federal Rules of Criminal Procedure 16B1 alpha.
All right, so it can be used in the state's case in chief and maybe be impeachment evidence, maybe be substantive evidence, maybe be both. It's not where in the trial it comes in that matters. It's whether it's used and intended for use as substantive evidence or not.
That is, yes.
Okay, so as long as we're all on the same page with that, and I actually do think that to the extent anybody might want to take a closer look at what those distinctions are, I think it's Waddell,
Yes.
where the court actually says, hey, you know what, these can be tricky, these can be dicey. Here's what it means. Here's the difference between the two. So I would recommend for everybody's reading pleasure the court's exposition of that issue in the Waddell case.
And in this amendment, I did correct
All
the
right.
Waddell site.
Okay. All right, so we'll follow that law as well.
So, Your Honor,
Yeah, and so I guess I don't know if you've got specifics with regard to things that you believe have not been turned over or that exist and haven't been turned over.
Well,
Okay.
I cite, for example, in these amendment to the supplement on page 1, the first example was recordings that were held by counsel for defendant Williams of an interview conducted with state's witness Adrian Bean. The evidence that was shown at trial was that Mr. Bean was a co-conspirator with defendant Williams in an intrinsic armed robbery. The state conducted days worth of direct examination of Mr. Bean, only to learn the weekend before the day cross-examination of Mr. Bean was to begin that counsel for defendant Williams had a recording of an interview he had conducted along with his investigator, which had been in counsel's possession since January of 2023.
Okay.
In which Bean claimed that defendant Williams was never involved in the armed robbery, and in which Bean claimed that the police told him to put defendant Williams in the crime. Mr. Williams presented this statement not just as impeachment evidence, but as substantive evidence, and further based upon information provided by Bean to the state upon information and belief. The recording that was given to the state was only a portion of the recorded statement at issue. And we do not have, if there are further statements, if there are further recordings, we don't have them. We've not been offered them. We don't know what they consisted of. Another example is defendant Williams has asserted verbally that he is in possession of a video recorded statement of the witness currently on the stand, in which that witness reportedly asserts, "We killed Nut," referring to Mr. Donovan Thomas. The state is not in possession of any such recording, is unaware of the existence of one, but as I stated earlier, Mr. Williams has asserted verbally that he has such a statement. Mr. Copeland, as I stated, is currently on the stand, and the state has not been given any such recording or been privy to or been able to review any such recording despite a specific and direct request for it. We assume that defendant Williams intends to use the recording, if one even exists, not simply for impeachment purposes, but as substantive evidence. Given these explicit and deliberate decisions to withhold material specifically that we've outlined above, and I will also point the court's attention to a similar example of with intentionally holding back material. There were jail recordings of the witness on the stand now, Mr. Copeland, that apparently defendant Williams has had in his possession for quite some time, long before Mr. Copeland took the stand. And we were only around the time that Mr. Copeland took the stand presented with these recordings. We expressed having a problem with being able to access them, and we were given another set of recordings that contained some other files that maybe were missing in the first one. But the withholding, the deliberate withholding of these items is what has prompted the state to ask the court for relief here. We are not asking the court to exclude late, disclosed discovery. That's not what we're asking for, but deliberate intentions to withhold information that a defendant intends to use both as substantive and impeachment at the same time. Evidence. We are asking for the relief that we have referenced in our initial motion. And if the court is not inclined, as we've stated on page 5 of our amendment and supplement to the state's motion to compel, we recognize that both Georgia and federal authority instruct that courts employ the least extreme sanction to remedy discovery violations. If the court deems exclusion of a particular piece of evidence too extreme, the state requests that the court issue an order directing defendants to permit the state to inspect and copy any and all material that a defendant possesses, which the defendant intends to admit as substantive evidence, even if the material is also impeaching of a witness, and directing that where the proffering defendant intentionally withholds such material, that it be admitted, if at all, solely as impeachment evidence, and with a limiting instruction prohibiting the jury from considering it as substantive evidence.
All right. So, with regard to the three things that you outlined specifically, you now have the recordings of witness being, is that true?
We have one recording of witness Adrian Bean that apparently was made on an iPhone, but is, according to the information that the state received from the witness as he got off the stand, that may not reflect all of what was taken down.
What do you mean by taken down?
Well, there were, as the witness left the stand, he indicated that, and actually on the stand, he instructed Mr. Steele to keep it 100, implying that that's not everything. In other words, that what we were hearing was not everything. The recording itself was kind of degraded, and we were not, it did not appear to be one pulled directly off an iPhone the way that an iPhone would the quality of an iPhone recording would be. And I apologize to the court, but there was one more instance. D'Angelo White was a witness that the state put on the stand, who represented to the state that that counsel for defendant Williams recorded the interview, or appeared to be recording the interview that he conducted with D'Angelo White at the Fulton County Jail. We've never received any recording of an interview between counsel for defendant Williams or anybody else conducted at the Fulton County Jail. I believe I heard earlier reference today to, I don't know if I heard that was the subject of any ex parte hearings or meetings with the court between counsel for multiple defendants and the court. But if there were or are any interviews of D'Angelo White in anyone's possession or that were made, we would believe the state to be entitled to them. He was a witness who was examined and cross-examined on the stand. So there were 4 instances.
All right, well, he already has been examined and cross-examined?
Yes.
Okay, and no such recording was used?
Right, they didn't.
Okay, then why would y'all be entitled to it?
It's just an example of something that we weren't aware of.
Okay, but y'all aren't entitled to be aware of every aspect of a defendant's case.
I don't disagree.
You are entitled to something that would have been a recording that then gets used as substantive evidence, but it sounds like that did not.
The court is
right?
correct.
Okay, so that one doesn't
scratch
matter.
it off.
Okay. So Mr. Williams saying he has a video recorded statement of Mr. Copeland saying we killed Nutt, which he might want to use as substantive evidence, as well as any jail recordings of jail calls of Kenneth Copeland, I guess, with anybody, I would assume.
And we have been...
Y'all got all of those too, right?
So we have been provided, these were not jail call recordings from the Fulton County Jail.
Okay.
They were from a different, but we've been provided, according to defendant Williams, counsel for defendant Williams, we've been provided all that they have.
Okay.
And so if that is the case, then there is no further issue.
Okay. So that one's fine too.
Correct.
So, Mr. Steele and or any other defense attorney, if you have recordings or statements or anything like that that you intend to use as substantive evidence, whether it is in a case you might present later or the state's case, I think you know this, but need to disclose that to the state. Now, if it just comes up at the very end that, oh my gosh, I didn't know I was going to use this, but now I think I want to, then we might have to sort out whether that's in fact what's going on or not. But I expect everybody to abide by their discovery obligations. If I end up making a determination that somebody is willfully failing to abide by those obligations, then I will consider sanctions. But I would hope at this point, and with what I've already heard, I haven't really heard anything that I find alarming and improper. So unless anybody wants to say anything else, I'm just at this point going to say I expect y'all to abide by your discovery obligations.
And Your Honor, if I may add one more thing, I believe that counsel for defendant Williams emphatically stated he does intend to use a video recording that he has in his possession of the witness currently on the stand purportedly saying what he asserted, and that we're
Okay, well, I mean, I can see how that might be impeachment evidence, and I'll have to hear whether and how it might be substantive evidence. Mr. Steele.
I have 1 second, Your Honor?
Sure.
Thank you.
This is a long second, Mr. Steele.
No, hopefully it'll be worth it. Your Honor, may I approach?
Yes. Thank you.
Thank you, Your Honor. So I believe that what the state has asked you to do and what you said from the bench about the law that will apply in this case is not accurate under Georgia law.
Okay.
I also, again, I'm not going to continue to repeat. I hope that you would take it the way Judge Glanville did. I have all objections to any proffer made by District Attorney Love. They are not only wrong, but I'm going to show you why they are knowingly wrong. This is the fourth time we're having the same hearing. I know you're not here privy to this.
Okay.
What Prosecutor Love did not tell you is the Georgia law that I've already handed to them. Judge Glanville has ruled on this 3 times.
Okay.
Every time telling the state the same thing, that they're wrong. So I'll go through it for the 4th time that Ms. Love intentionally, I assume, she has a memory of this because she was here. I handed her all these cases. So I assume that she's doing it intentionally. First of all, what she has told you about the case in your reading of Waddell is not accurate. The original case that the state is using is a case from the 4th Circuit called United States versus Young. Young is what Waddell talks about.
Okay.
If this honorable court would look at United States versus Harry, which should be in your package. I may not have put this in perfect order because one of them were not stapled, but you should have a United
got
States.
it.
Okay, and Harry is Harry, and it is 2014 U.S. District Lexus, which is Lexis 160233. And what happens in the Harry decision is the district court judge in New Mexico analyzed a beautiful analysis of the Young case. And that starts, Your Honor, on page 11 of 17 of the copy I've given this honorable court and the parties. And if you can turn to that page, if you don't mind.
I'm there.
On the left-hand side, the first full paragraph. And it reads, in United States versus Young, which is Y-O-U-N-G, the 4th Circuit did not explain its decision, but held only that the district court did not abuse its discretion. The holding in United States versus Young may be explained by the fact that the 4th Circuit was applying the previous version of Rule 16, which used the term evidence in chief. Unlike Judge Friedman in United States versus, and I'm just going to spell it if you don't mind, HSIA, the 4th Circuit did not define evidence in chief as case in chief. And then it goes through defining case in chief. The advisory note, I skipped 3 lines, Your Honor. The advisory committee notes to the 2002 amendments state that the change from evidence in chief to case in chief may be substantive in nature. The term evidence in chief may have, as the 4th Circuit held, encompass both the parties' case in chief as well as a party's non-impeachment cross-examinations. Even if the term evidence in chief encompassed all non-impeachment evidence, including cross-examination, this broad term does not mean that the term case in chief does as well. The 4th Circuit in United States versus Young indicated that a party's case in chief encompasses the time in which the party calls its first witness until it rests by repeatedly using the term case in chief in that manner. So I tell you this because the Waddell case goes back to the Young case. The Young case is a federal analysis of a rule that we don't have in Georgia. In addition to that, there have been 0 circuits following United States versus Young. Georgia has never cited Waddell or Young, but Georgia speaks directly on what our law is. And there's 2 different cases, Your Honor, with the same name of Green, Green. And if you can take a look at the most recent Green case, which you should have in your package.
Yes.
And for the Honorable Court Reporter, this is going to be Green, no E at the end, and it's 368 Georgia Appeal 74. 889 Southeast 2D 190, 2023. And what the Honorable Judge Pipkin, which is P-I-P-K-I-N, states, and Your Honor, you could look at, if you don't mind, at this case on page 3 of 5 of the copy I've given the parties. And this Honorable Court, footnote 3 is at the bottom left. And it reads, we also agree with appellant. This case was reversed. So let me just take a step back, if I may. what happens is the state did exactly in the Green case what Ms. Love is asking you to do here. They said that the lawyer for Mr. Green had evidence for a while, didn't turn it over until the day of trial. The judge excluded it because the quote, and this is a quote, sat on it too long. Therefore, the state was prejudiced and excluded the evidence. And the Court of Appeals said, you know, there was no evidence of bad faith or prejudice analysis, so we're reversing. But they dropped this footnote. And the footnote they wrote, and I'm quoting, "We also agree with appellant that it is not at all clear that the defense failure to timely disclose," and I'll just tally them, but TALON''S note was in fact a discovery violation, given that talent was a state's witness. See OCGA section 17-16-7, requiring the production of statements concerning the testimony of witness. That, and it's in italicized, so it's stressed, the party in possession, custody, or control of the statement, and then in italics, intends to call as a witness at trial. I didn't call these witnesses. I don't intend to call these witnesses. The next line goes further, and I'll explain it if you don't mind. It's very easy to explain.
Yeah.
However, we assume, I'm just reading the footnote, for purposes of this opinion, that the note was subject to discovery, and we need not resolve the question or address any possible tension between, and then it gives the two code sections that we're dealing with, OCGA 17-16-4, little b as in Barry 1, and OCGA section 17-16-7. So if we look now, and I should have given this honorable court and the parties a copy of both code sections, OCGA section 17-16-4. If you look at that first, assuming everyone has it, and it starts for the criminally accused obligations under the Discovery Act, and Mr. Williams did, in fact, opt into discovery. And if you look at the copy I've given this honorable court and the parties, it starts on the very bottom of page 2, but it just says B as in Barry, but it really goes over, Your Honor, to page 3. And that's where the 1 is in 17-16-4 in the copy I've given. And it says that the defendant, within 10 days of timely compliance by the prosecuting attorney, but no later than 5 days prior to trial, or otherwise ordered by the court, shall permit the prosecuting attorney at a time agreed to by the parties, or as ordered by the court, to inspect and copy books, papers, documents, photographs, tangible objects, audio and video tapes, films and recordings, or copies or portions thereof, and to inspect and photograph buildings or places which are within the possession, control, custody, or control of the defendant. And this is what I stress, Your Honor, it's stressed in the footnote, and which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at trial. Your Honor, under OCGA section 17-16-7, if you look at that, and I've given a copy of that to this honorable court and the parties. And that has, if you give me 1 second, that has no later than 10 days prior to trial, or at such time as the court permits, or at the time of any post-indictment pretrial evidentiary hearing, other than a bond hearing, the prosecution or the defendant shall produce for the opposing party any statement of any witness that is in possession, custody, or control of the state or prosecution, or in possession, custody, or control of the defendant or defendant's counsel, that relates to the subject matter concerning the testimony of the witness, that the party in possession, custody, or control of that statement, and this is what I stress, intends to call at the trial or such post-indictment pretrial evidentiary hearing. I didn't call these witnesses. So the reason that it is so important is we're just dealing with who's case in chief. Georgia doesn't have the pre-2002 Rule 16 analysis that was done in United States versus Young. This is not even close. Page 5 of 7, and Your Honor, I am now in the other green. So it is GREEN versus State, but it's 307 Georgia 171, 835 Southeast 2D 238. It's a 2019 case. No relation that I know of. It's in Division 4. It's on page 507, like I said. Left-hand side, the last line before the footnotes, 2 lines up, actually. It says, however, that is not what Georgia law requires. As provided by the plain language in 1716-4B2, the statute does not require a report to be prepared and made available or served unless the defendant intends to introduce in evidence the defense, I apologize, in the defense case in chief or rebuttal the results of a scientific test or experiment. If you go to the next case, which should be, or another case, I don't know if they're in order, but it's Carmichael, Your Honor, which is CARMICHAEL versus State. 353 Georgia Appeal 64. That's 836 Southeast 2D 184, 2019 case. And Your Honor, if you can turn to, from the copy of Guinness Honorable Court and the parties, page 7 of 8. And Your Honor, this is on the left-hand side, the first full paragraph, but counting from the bottom. 1, 2, 9 lines up on the right. I am quoting from our court, and this is just one case. There's so many. Just before the state rested its case in chief, the trial court instructed the jury that when a stipulation is entered into the facts, as to facts by the parties, you can accept those facts as being true without further proof. My point is, their case in chief is, it's a term of art.
It has a distinct meaning.
Yes, and if you go back to the Harry case, it's actually a fascinating case to read. It's an enjoyable case to read. They go through case in chief versus evidence in chief, and they talk about specifically all the U.S. Supreme Court cases. It's on page 8 of 17 of United States versus Harry, Your Honor. It's a well-written, it's really a good job. On the left-hand side, the first full paragraph on page 8 of 17. And the district court in New Mexico wrote, courts have repeatedly used the term case in chief to refer to the part of the trial between the time that a party calls its first witness and when it rests. And then they go through all these United States Supreme Court cases that talk about that. I mean, it's not even an issue. So I, for the 4th time in doing this, the state then has, or the court said that wants to know about Waddle. Waddle is different. Waddle specifically, and I assume that you have the case because I heard you refer to it. If not, I can get it.
I do. So
in United States versus Waddle, which is WADDELL, and it is 2016, 2016 U.S. District, which is DIC period, Lexus, LEXIS 68748. It was decided and filed on May 25, 2016 by the district court in Southern District of Georgia in the Savannah Division. Your Honor, if you go, and I'm not saying we have the same copy, so this is on I have page
maybe what page of the slip opinion?
I'm trying, I think it's page 11 is what I'm looking at. It starts out with one final point. Okay. So Waddell case, the judge said, no, you don't have to give it over, but if you're lying, that's, I think, I'm not saying that's
Right. No, I read it. Yep.
Then you're going to be in a lot of trouble or something to that effect. But what happened in the issue in Waddell was they were talking about a statement given to the accused before the indictment. So it wasn't done under the auspices of work product, where the lawyer goes out and interviews witnesses. What Ms. Love tries to do is, I would have a chilling effect. I interviewed every witness that would talk to me. I interviewed everybody. And what Ms. Love is saying is, give me your work product. If I'm not going to use it, The way I understand the law, unless you tell me differently, I'm not giving it to the state. So
That's my understanding as well.
So when she says, Mr. White, and I heard what you said, they didn't use it, why would you ever get it? That's exactly right. I hardly cross-examined Mr. White. But the state is telling me to give it. They went so far as Ms. Love called our investigator and tried to get involved and break the attorney camp. She told our investigator, she can call me, give me any recordings that you have of Mr. Bean. Now, the investigator's skilled. So he must have said, I wasn't on the phone. But Ms. Love then reported it to Judge Glanville, who said that was appropriate. He shouldn't have given you anything. Said, Mr. Steele's investigator's obstructing us. This is so wrong of the prosecution. 4 times I've given the same case. 4 times I gave that Green case. 3 times Judge Glanville ruled. In addition to that, there's factual, not only, am I rejecting, I am never taking Ms. Love's proffer. Okay, so she says that I said, I don't talk with Ms. Love, by the way, if you didn't know that. So I never said anything to her. But that I said...
Is there somebody on the state's case that you are able to talk to?
Yeah, Ms.
Okay.
Willis.
All right. Well, okay.
On
Go ahead.
the second page, and I'm just looking at the amendment to supplement, on page 2, in the center of the page.
Right.
And I should start above, but I'll get to that if you don't mind. For another example, Defendant Williams, it's me that she's talking about, has asserted verbally that he has a video recorded statement of Kenneth Copeland in which Copeland reportedly asserts, "We killed Nutt," referring to Donovan Thomas. Well, let me tell you how that happened. I never said that. Ms. Hilton sends an email and says, upon interviewing Kenneth Copeland, we found out that he put out a social media recording that he killed Nutt, or we killed Nutt. It's in writing. Can you please give it to us? We can't find it. The most I may have said, which I don't have a memory of saying anything, is I'm not giving you anything. If I use something, I'll use it in court. That sounds like something I would say to these prosecutors. To other people, I would say, you're going to have to, I don't have to give it to you, and I'm not going to be able to talk about that. I never said, I verbally asserted that I have anything. But if I do, I'm going to say the same thing that I'd always say. I'm not giving it to them. If you tell me to do it, I'll do whatever. But I'm not going to give them anything because I don't have to. That would be impeachment. Mr. Copeland, before the 12th day of June of 2024, specifically was asked by Ms. Hilton, did you kill Nutt? And he said no. That would be impeachment. The next one, that I did not give over Mr. Copeland's jail calls until recently. Let me tell you the truth. October 2023, I gave jail calls of Mr. Copeland to the state. October 2023. The state doesn't raise this until more recently when Mr. Copeland is a witness. They want me to tell them which jail calls am I going to use to impeach the man. I said I'm not going to do it. Judge Glanville said you don't have to do it. I'm not going to do it unless you tell me to, but I don't understand how I'm doing this. Yeah. And then to stand here and say I just gave it to him is preposterous. In addition to that, then we go to the first one, Mr. Bean. Mr. Bean testified for days. This case, Your Honor, has taken so long. I don't know how long he was on the witness stand. It would not shock me if he was there for 3-4 days. All he said was, I don't recall. That's what he said. I don't recall. Did you say this? I don't recall. I don't recall. So the state got in his prior statements to Detective Quinn. Well, I impeached him. He gave me a statement on recording. The state then doesn't ask Mr. Bean in front of the jury, doesn't ask him in front when he's here to be cross-examined. They come up with the Judge Glanville ex parte, give him some sort of document that supposedly shows Mr. Bean is scared, which I doubt. This is just me doubting, I have no evidence. And then in the middle of that document says that Brian Steele and his investigators, I'm not quoting, were in a car with Mr. Bean and his son, and Brian Steele was telling Mr. Bean what to say, and his son has that on recording. That never happened. That never happened. But what Ms. Love was allowed to say in front of the jury, believe it or not, did Mr. Steele stop and start that recording? Mr. Bean said what he always says, I don't recall. I objected outrageous. Outrageous. It just flows right through. The same way Ms. Love stands here today and says it's hard to hear, or whatever her words are, hard to decipher on an Apple iPhone. That did not happen. It is offensive. The legal analysis is wrong. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong, and this lawyer knows it because she sat here in court and I did the same thing without being tempered.
All right.
That's 4 times.
Thank you for clarifying that.
Your Honor, may I briefly respond?
Yeah, when Mr. Steele clears the area. Yeah, go ahead, Ms. Love.
Thank you, Judge.
Do you have any Georgia law that represents what you have asserted in your motion and amended motion?
Your Honor, that's just it. I have been clear in my amended motion, and to the extent that it wasn't.
Which I just got a copy of.
Yes.
Okay.
And also, I just want to say that.
No Georgia law that.
Right. Georgia law does not define, it does not define case in chief. It does not break it down.
We all know what a case in chief is. Don't we? I think we all know what a case in chief is. Is there any support for your assertion that reciprocal discovery is required based on the concept of substantive evidence?
Your Honor, what I have said and what I maintain is that, one, there is an absence, and I'll point the court to 3 different cases, Harris versus the state, 314, Georgia 238 as one. And these are just instances.
238? What did you say?
Yes.
Okay. What are the other 2, and what are they going to represent?
307 Georgia 171, which is the 2019 Green case that Mr. Steele cited for the court, and 146 Georgia App 423, which is Phillips versus the state. And
When is that from?
I'm sorry.
What year?
Just 1 second, Your Honor. That's a 78 case.
Okay, so that one's not relevant at all.
Old case.
Because we have a new evidence code since 78, so, okay.
And Your Honor, even with respect to the older case, the only thing that I was citing Phillips for was the proposition that in the absence of specific legislative or decisional case law on the particular issue that is at hand in Phillips, we commend the Federal Rules of Criminal Procedure, Rule 16, for guidance.
Well, we've got a specific rule here now, don't we?
Well, when you say we have a specific rule, is the court speaking of the discovery statute that says?
That's what we're talking about in this motion, right?
Right, yes, Your Honor. We are talking about that, and the state's position, the state maintained, first of all, let me be real clear, we didn't file a brief. This is the first brief that we have filed where we've asserted these things. We have asked that the court require Mr. Steele to turn this stuff over, but we've never argued it out. Mr. Steele has stood up and said he's not required to, and he has pointed to the discovery statute. The court has said, okay, yeah, he doesn't. And we put that in our motion to the court, that the court has previously made a ruling that we thought deserved a second look at. Defendant Williams has adopted as his witnesses all the state's witnesses in the witness list that he filed. And so, Your Honor, when we assert based on Waddell. And Waddell also speaks about work product, and it makes this distinction between factual history and work product and what the state or is and is not entitled. The state stands on its assertion regarding what the requirements are because of the fact that I understand the court's position that there is no misunderstanding about what case in chief means in Georgia, but as there was this expounding on its meaning in Waddell, I think it's important to recognize that there's not been a similar sort of expounding in Georgia, and we can all presume or take for granted that it just means when the defendant is putting up his particular case. Right.
Okay, so do you have any case law
in Georgia
that supports the position you took in your motion that reciprocal discovery requirements are triggered based on whether you're presenting something as substantive evidence? That's my question to you.
Your Honor, the only, what we have in support of the motion is cited in the amendment and in the motion itself. We have not ever presented or represented to the court that there was a Georgia case that addressed this issue, and the conclusion that is asserted in the state's filings are the result of the fact that, one, from our position, it's not addressed directly, that, you know, what case in chief specifically.
So you are telling me that when our discovery statute says that the defendant is to produce or permit inspection and copying of whatever it is that they're in possession or control of, which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at the trial, you think that there's some kind of lack of clarity about what that means? Is that what you're representing to the court?
Your Honor, I'm representing that was the position that was taken. That was what was analyzed in the cases that we have cited in our amended amendment and supplement to our motion to compel. That is, in our position, a reasonable interpretation. And as we've said in our filing, Your Honor, there was the requirement in Waddell that anything that was within the defendant's possession, custody, or control, where the defendant intended to use the item in the defendant's case in chief, that be turned over. The Waddell court, Your Honor, in analyzing the meaning and understanding of case in chief, as the court correctly pointed out earlier, said that if it is going to be used as both impeachment and substantive evidence, that constitutes case in chief. From there, we made the assertion, the state's position, that if the defense intends, because there's nothing in Georgia law that analyzes it at this level, if the defense intends to introduce evidence as both impeachment and substantive evidence, then they have a duty to disclose it. And that is the origin of the state. That is the basis for our position. If you're
right. And have you heard Mr. Steele argue 2 or 3 times before that that's not at all what Georgia law means?
We've not made this argument before, so
I don't mean in writing. Y'all have not had any discussion whatsoever in front of Judge Glanville about.
As I have said in my motion, Your Honor, what we have argued, the state has said, Your Honor, they have a duty to disclose this. This is stuff that we are entitled. And Mr. Steele has said no, in citing the Georgia statute. He said we do not. I have never asserted, I've never made this distinction. I've never said that case in chief means if it's being presented as impeachment as substantive evidence. I've never made that argument in a written or oral filing.
Okay. All right. Well, I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms. Love.
Respectfully, I take it very seriously.
Okay, so anyway, we'll be abiding by the discovery requirements set forth in our statutes. And Mr. Steele, thank you for the clarification. All right, I think that brings us to the issue of when we first met, Mr. Shart had suggested that there might be, well, I don't know if it was Mr. Shart or Ms. Love, honestly, one or the other of you. We discussed the possibility that there might be outstanding discovery that maybe actually was required to be produced that either was missing or just hadn't been talked about. And I wanted us to kind of go through in detail what it is that everybody thinks maybe the other side has that they're entitled to that they haven't gotten yet. So are we in a position to be able to do that now? If not, we can do it tomorrow or the next day and we can move on to, we've got other stuff to do too. Which exhibits have actually been admitted, if that's an easier one for this afternoon? Which would y'all rather? We got to do them both, so I don't really care which order we take them in.
Speaking for the majority on this side of the room, we'd ask if we could take that up tomorrow.
Okay, so can we do then today, I think Mr. Steele provided sort of as a starting point, a list or a chart or a spreadsheet or something of his understanding of what exhibits have actually been admitted. And for us to take this pause is a good time to make sure we're all on the same page about that. And I know that Ms. Weaver, the court reporter, had at least provided to me, but I don't know whether she copied y'all or not, a couple of places based on that chart where she thought she wanted some clarification, or she thought maybe it had been talked about but not actually admitted, so we can go through all of those. Do y'all have that, or do I need to get y'all that?
Your Honor, we have that. I believe that might be a rough draft. We have been keeping a list as well, and
Okay.
we have been referencing the recorded proceedings to ensure that we are accurately keeping note of what has been and hasn't been admitted. As I stated earlier, there have been instances where it has been proffered that evidence has been admitted, it has been tendered,
Right.
that has not been the case. So we are still, and we would ask that the court allow us to get a little bit further along in checking all of these exhibits.
All right, so
what has really and truly been admitted.
so the question was, do y'all have the kind of response from Ms. Weaver about her take on a couple of discrepancies? Okay. Ms. Percefield, could you share that with everybody? And I was hoping that we could do this today. If the state is not ready to yet, you know, I want to try to take us to the end of the day because we have a lot of work to do. Maybe there's something else that we still need to cover that we could cover today.
Judge, we are going through each piece of evidence, and we are comparing our record with the actual physical piece of evidence that we have submitted or defendant has submitted. So that endeavor is...
I'm sure it's time-consuming, voluminous.
And we have endeavored to make certain that it's accurate, so...
Well, that'll be helpful. We would want that. All right. So, Ms. Percefield will email out to y'all all the couple of comments that Ms. Weaver, in her looking back, believes might be inaccurate on the chart that Mr. Steele has put together and shared with everybody. So y'all can take a look at that. We can deal with it tomorrow. I know one thing that we're going to need to sort out. Ms. Weaver had mentioned that there are times when, and I think she said it was, I don't know who, but somebody on the defense side, or maybe more than one person on the defense side, I don't know if the state's doing it as well or not, but you will approach a witness with a laptop and show them something on the laptop and ask them about it, and that it is difficult for the court reporter to then sort out what was that exhibit actually, and I don't know if anything has been admitted that way, but I do know that the prior judge, there is an administrative order filed in April in this case that requires all evidence offered by any counsel be submitted to the court in physical form and marked as appropriate at the time of its admission for it to be properly made a part of the record, and directing counsel to provide physical copies to the official court reporter, who now obviously is no longer Ms. Weaver for going forward. It is going to be our new court reporter, Ms. Winfrey. But we actually need, electronic copies too, but we need something that is physical, whether it's on a jump drive or a flash drive, or whether it's a piece of paper. There's no way for the court reporter to capture sort of, I guess, a screenshot, unless y'all take a screenshot of the screen that you're showing the witness and then give that piece of paper or electronic file to the court reporter. That would be fine, but there has to be something that represents whatever you showed the witness on the screen, okay? Does everybody understand? Anybody have any questions about that? Okay. So we can take up tomorrow, after y'all have had a chance to look at it, the couple of issues that Miss Weaver's got a different record than what Mr. Steele does. And then I would love for y'all to be able to get together on, if there's no discrepancy, then we don't have to worry about it if everybody's on the same page. If there is a discrepancy, if y'all don't talk to each other, maybe you could just email each other. Here's where we think there might be a question or an issue, so that we all know before we talk about it what it is that we need to talk about. So can y'all do that this evening? Don't ever, thank you. Okay. All right, very good. All right, the state has provided an updated witness list, which is still fairly long. And I would like to know from the state, does that list include, is that just the witnesses that have been called yet that still need to be called, or does that include everybody, the witnesses who have been called and those who are still to be called?
Your Honor, that includes the witnesses that need to be called. Some have already been called, but those are everyone moving forward.
There were a few you highlighted and said we may recall these. So that is 105 or so witnesses still to go, though?
Yes. Okay.
And is that with y'all narrowing it down and picking only the witnesses y'all need?
Yes.
Okay. Well, we'll see. But, all right, are there any other, we've got to figure out how we're going to deal with Mr. Copeland's sort of redo, but are there any other motions that I haven't gotten to yet today or mentioned today that are outstanding?
I emailed Your Honor's chambers regarding motions that I filed and because I did not have access to Odyssey and I could not pull them off the internet, and I did not have the file copies on my computer. I identified what they were, but they were essentially, I would think they're titled notices of objection. They were regarding, Your Honor may or may not know this, there was a wiretap in this case. There's, then also my client's phone, actually 2 phones, were extracted and dumped. So there's numerous phone calls, texts, emails, things of that nature that are on either the wiretap that were intercepted, some involving some with my client as a party to those communications, some not, as well as all the things that are typically on a cell phone that deal with someone's essential life on an electronic device. The state has, to my knowledge, not identified what they plan to use from either of those sources of information at this time. And that's why I labeled it a notice, because there is irrelevant information, there is prejudicial information, there's on the wiretap, not so much Mr. Stillwell, but there's other individuals on these wiretaps discussing all sorts of other acts that have nothing to do with this case. And so there's just a lot there, and we're going to need to have that discussion at some time.
Okay, thank you. When does the state intend to let the defense know what it is they're actually using out of the universe of all possible things?
Your Honor, what I think that we have represented to the court previously is that prior to, I believe we had said at least a week before, because there is a large volume, to say the least, of calls within the jail calls and within the wiretap that are that have been turned over in discovery. And I believe that we had previously said that did we say the week before? 2 weeks before we intend to use them, we would apprise defendants of which ones.
Can y'all explain to me how you are dealing with a large volume of what ought to be motions in limine while in the midst of trial? And still being in any way efficient with the jury's time? You're not, essentially. Okay. All right. That's just not practical. I mean, we're going to change that going forward. And I'm not going to say I need you to know everything tomorrow, because I know it's a voluminous case. But y'all been putting this case together for 2 years. And you ought to know, I mean, you clearly know what witnesses you're going to be using. And you've given me, you know, kind of a very broad idea of what exhibits you intend to use with those witnesses. But I don't know that if we're just every other week saying, okay, let's figure out all of the evidentiary issues that have to do with the next 2 weeks worth of witnesses. We can do that in one day on a Friday. We just can't. So we're not going to be able, I mean, we all know that we've got this week. And we know that the jury has already been told before I became involved that they essentially have the week of, what is it, August 19th out. So, you know, this week might be taken up pretty much with sorting out the 2 things I just mentioned, and then sorting out all of the evidence that goes along with Mr. Copeland, because he's our next witness up. But the week of August 19th, we need to be plowing through a whole lot of other evidence, not just what's coming up in the next 2 weeks. We need to be covering the next several months, which ought to be, frankly, the end of this trial by then. I mean, it should not take another 7 months. It shouldn't. Whether it does or not, I don't know. But so the state needs to produce in much more detail a much more winnowed down but comprehensive list of what the evidence they intend to use with each witness is going to be, so that the defense can see it, evaluate it, make whatever evidentiary objections they have to it, and the court can have some time to view the evidence, listen to the evidence, whatever the evidence is, and evaluate the evidentiary issues, so that we know by the time the witness gets on the stand, here's what is coming in. I mean, for the most part, it's a trial, but what's coming in and what has already been excluded. So do I need to be more explicit about that, or do y'all understand your marching orders?
Yes, we understand what the court is asking.
All right. So, like, I feel like I need to be more explicit about it, even though I know y'all understand. By the beginning of next week, I want to see, at least the next 30 witnesses worth of evidence, okay? And then maybe by the end of that week, the next 30. Okay? All right, and we're going to plan to be here all of the 19th, and I don't know when else we're taking breaks, but, okay, so that's that.
Can I ask a clarifying question, Your Honor?
Yes.
And Mr. Adams and I, Attorney Adams and I filed, I think that motion, it was not helpful just say like witness Kenneth Copeland, jail calls, social media. I think you just covered that though.
Well, in fairness to the state, I do think that when I asked them for that, I said kind of broadly, let me know what evidence. And now I'm asking for it in more detail, just because practically speaking, in the middle of a trial, we've got to sort out what evidence is admissible. And ideally not while the jury's sitting there waiting on us.
No, that's perfect.
Okay.
We appreciate it. The specifics will make us roll better anyway.
Yeah.
Thank you.
All right. So, any other motions that are still needing to be addressed? And y'all, it's 3:30, and I plan for us to do work until 5:30, and we can take a little break, but I'd really like for us to figure out something that we can make some progress on for the next 2 hours. So let's take a 10-minute break, be back, well, it's 3:34, be back at 3:45, and y'all think in the meantime, all right, what can we use this time productively to do? Thanks. y'all are just coordinating.
Well, maybe we'll get that back.
Somebody on this side of the courtroom actually has some kind of a speaking relationship with somebody.
Your Honor, we
All right, attorneys, try to be back by the time I say be back, okay? Try to be back by the time that I say to be back.
Yes, Your Honor.
Thank you. There we go. Because I want to be efficient with y'all's time too. Okay, did anybody come up with anything else that we can be productive about today? All right, what is it?
I don't think my mic works that well, so I'm going to come up here. There are, way back when, and we're looking for the filing right now,
Okay.
there's back in, I would estimate, June of 2023, maybe. There was discussion that we needed to know all the alleged co-conspirator statements that the state intended to use, as well as any and all extrinsic acts that the state intended to introduce evidence of at trial. My recollection, and I would defer to that filing, was that there was only 3 801D2E
I don't know.
co-conspirator statements.
Okay.
There was only 3 listed, and then there was also a certain number of extrinsic acts that were listed. Throughout this trial, the state has gone past that list, and that has led to much delay and litigation and sending the jury out. So I think that's something we could discuss.
Okay.
What if that is the entire list, which I submit it should be, we could discuss that. Also, there are, and I don't know if this falls under the discovery that we were going to talk about tomorrow, we are missing the reports of many experts
Okay.
that the state plans to call, is my understanding. Also, Your Honor, there are, in this case, the state, I believe, has announced that they plan to call 5 different gang experts.
And they've called 3 at this point, is that right?
I believe that is correct. I believe
Okay.
it's 3.
So maybe explore what, if anything, the other 2 are going to add?
And not only that, but the state has announced the intention to call a few of them multiple times.
Okay.
So that is another issue that's continuously come up in this case. Am I missing anything from our list?
That should be enough.
That was it? Okay.
Okay.
So
all
those
right.
are the
Okay.
issues that we came up with.
Thank you. All right. And if the state needs the evening to, sort out everything and make sure that you're being inclusive in answering to the extent you know, that's fine. But if you know now, that's also fine. Do they have notice of all the different co-conspirator statements that the state intends to use and the extrinsic acts the state intends to use? Y'all can answer now, or y'all can say, give us till the morning.
Your Honor, I'd ask that the court just give me a moment. We're pulling up the.
Okay. All right. And while y'all are looking, I'm just going to make a general sort of admonition to not the parties in council, but anybody that wants to come in here to watch this case that, and I mentioned before, but I don't know, I may have to mention it a couple of different times. I don't expect there to be frequent up and down, in and out. That's distracting. So try to keep that to a minimum. There shouldn't be any talking in court other than the parties maybe whispering between the attorneys and the clients in the court. If you're watching the case in here with us, and you need to say something to somebody else, step outside to do that. There doesn't need to be any kind of, it's just distracting. There's a lot going on and there's a lot to pay attention to. And when we've got other conversations going on, it's that much harder to focus on what we and I need to be focusing on. And I also want to make clear that the deputies in here have my full authority to manage this courtroom. So if they give you an instruction, you need to abide by it, okay? And I'll probably, and I'm not talking about or to anybody specifically in here right now. Just some things I've noticed so far, and I, again, will probably make that announcement a couple of different times in the upcoming weeks so that everybody is clear on what the expectations are. Yeah.
The co-conspirator statement notice, who should I email?
To whom should you what? Send it? Ms. Percifield.
Your Honor, to the extent that the court's question was specifically, have we noticed the defense of the evidence of intrinsic acts? Is that the question that the court asked?
No, I mean, maybe it wasn't very artfully formed, but to the extent you can, to the extent you know, and hopefully you know since you're in the middle of your case, I would like for you to make sure that you have given the defense notice of whatever co-conspirator statements you intend to use, and then separately, whatever extrinsic acts you intend to prove.
Okay.
Okay.
All right.
And if you want to do that now, that's fine. Otherwise, that's something we can go over in detail tomorrow.
Judge, I'm looking at simply, I'll start with just the intrinsic acts, and I'm looking at 51 of them. I'm not sure about the 3 that were referenced, but within the intrinsic act notice that we filed on November the 6th of 2023,
Okay.
we made specific references to 51, and we also said acts contained within this non-exhaustive list. We referenced that the list was non-exhaustive, and we noticed the defense of the state's intent to introduce evidence of these particular acts. If the court will permit me one moment, I just wanted to call the court's attention to the November 6th.
Okay, so given that you noticed 51 but said it was non-exhaustive, that sounds like there might be others. So at this point, can you make the list exhaustive?
Yes.
Okay. And then the 3 was co-conspirator statements. Well, we don't need to take court time now. How about you can you have tomorrow, by tomorrow, what all the co-conspirator statements are going to be? And then how much time do you need to make the other list exhaustive?
So, Judge, what we're discussing is the number of co-conspirator statements that may be contained within the jail calls that we are also, jail calls and the wiretap calls that we are intending to introduce. And so, to the extent that we reference simply what we've filed, we can present that, but we would ask the court to allow us to address on the week that the jurors are out. The 19th?
So if it's anything with Mr. Copeland, that needs to get dealt with this week.
So with respect to Mr. Copeland.
Sure. Go ahead.
Okay, Your Honor. With respect to Kenneth Copeland, will the court permit the state to address in its entirety tomorrow the ones that we are intending to introduce? As we are discussing, those statements are contained within the videotape interviews and jail calls that we have intended to introduce and have noticed defendants of our intent to introduce. So in terms of what the specific statements are, I think we would best be.
Okay, so does everybody from the defense understand, at least with regard to Mr. Copeland, maybe not in detail, but what the universe of potential statements is for Mr. Copeland? I mean, y'all had gone through a lot of this and hashed it out once already, and you might not have gotten through everything, but y'all had done various statements and gone through in detail on what was in and what was out, and I know we might have to do that over again, but... And then there are jail calls that y'all had not reached yet, but I think the state had represented there were 5 or 6 of them, and y'all know which ones they are, so that y'all all know, right?
So we know about the jail calls.
Okay.
That assuming that the state's not expanding that list.
They're not going to be expanding that list, are you?
And
Not the jail calls from Mr. Copeland, no.
Okay.
and when they say noticed of things that are in his statement or his past statements, I am aware that I'm not aware of any co-conspirator statements by Mr. Copeland from, I'm aware of the Garlington to Copeland
Right.
statement.
Yeah.
But
From
I'm-
Mr. Copeland himself.
I don't, when they say they've noticed us on statements by Copeland that are in his statement, in his prior statements, I don't know what that
All right.
means specifically.
Okay. So are y'all including within that, like, here's what Garlington told me?
Yes.
Okay, so, all right. So that y'all do have, and are there, how many of those are there?
How many statements of Garlington to?
How many co-conspirator statements from any alleged co-conspirator are there that y'all are going to be introducing through Mr. Copeland? Or potentially introducing through Mr. Copeland?
At least 3 co-conspirator statements, 2 from Garlington that is contained within the June 10th interview. And then there's a jail call with Mr. Copeland and other unindicted co-conspirators as well.
Okay. So, defense.
If there's more, we can correct that tomorrow, but
Okay.
I'm thinking of.
All right, so take a look at it tonight and make sure. Okay. And then with regard to the other acts, do you want me to set I think it would be a good idea to have a deadline for giving the exhaustive list over. So do y'all want to make a suggestion as to how long y'all need to do that?
Just 1 second, Your Honor. Monday, Your Honor, is that?
That's great. Yes, that'll work. So that'll be Monday, August 5th.
For the intrinsic act.
Yes. Okay. Moving on to discovery reports of state's experts. Did you know specifically which reports or which experts you feel like you're missing reports from? Yes. Okay.
Your Honor, I just asked my coworker that I'm privileged to work with to email to your Honorable Court's coworker and everyone else the November 17, 2023 written order on this topic. And I don't know if this court has seen it, because, and if you want the court reporter to be emailed out, I didn't do that either. Apologize. But we had a hearing on this on or about August 21, 2023. Opening statements were approximately November 27, 2023. And we have no reports of any gang expert. We got a PowerPoint the day of testimony from the first witness is my memory, but if I'm wrong, I apologize and please correct me. And that PowerPoint had to be gone through and had to be excised. His name is Detective Belknap, which is B-E-L-K-N-A-P. Then Detective Dennis testified. He was allowed over strenuous objection to say that we did this work, and we spoke with witnesses, and we spoke with victims, and we spoke with co-conspirators, and we spoke with people who identify themselves as a gang member in IF or a gang member in YSL. And based upon that, we know that the following crimes occurred, and here's some 911 calls. I don't know who these people are. We have no background. That's in my opinion, that's a confrontation clause violation because it's the police officer doing the work. We never got any reports. When I've asked for the reports, I was told that that's under lock and key by the City of Atlanta Police Department. And he, meaning Detective Dennis, no longer works there and cannot get, they have a gang book. He described it as a gang book, but they can't get it. Detective Belknap said he cannot get access to give out that gang book. So we're basically in the dark and we're hitting as best we can, but this is all over objection. I have no idea how to challenge. Like you heard earlier today, there's a lot of information for the court, but you heard earlier today that, God forbid, it's at 7:22 p.m., the 911 call goes out and Mr. Donovan Thomas is shot. He's killed. It's on video. It's bad. It's a drive-by shooting. He gets shot. Multiple gunfire. 2 other people are shot as well, but thankfully not fatally. Within the next several hours, so it's 7:22, so within 5 hours, Mr. Copeland says that abodes that are close to his family members, and you heard a representation that Mr. Williams, they said stepfather's home was shot. I have no idea who shot that stepfather's home. I have no idea who to speak with about it. There's a 911 call about it. I'm not conceding that it was done by a gang member. That's why it's impossible to cross-examine. The next witness, who is deemed an expert by Judge Glanville, is a detective Gaither, which is Gaither, and she testified as well. I didn't make a report, but she goes into, I spoke with people, they're unnamed people, it's the same thing. I would like to know who these people are because I'd like to talk with them. Because if they say, no, I never said that, that's important for the jury to make credibility determinations. That has all been kept away from us. Judge Glanville ordered the state, and it's just, it's easy to read the order, but I wrote the order after the argument, but he signed it. In order to permit a meaningful opportunity to cross-examine all expert notes, reports, documents, statements, basis of opinion are required to be disclosed by each expert for the prosecution as to the underlying facts or data so cross-examination can properly, lawfully, and constitutionally occur. And that's right out of the case of Harris, Harris versus State, which is 314 Georgia, 238. It's in Division 6A, is in Elisa, 875 Southeast 2D, 659, 2022 case, where our Supreme Court said that is not the rule in Georgia, but we encourage trial judges who can control the proceedings to order that to be done, and Judge Glanville ordered it. The state never gave us those witnesses. Then you have Detective Belknap talking about, well, at APD, meaning Atlanta Police Department, we have six criteria that we designate someone a criminal street gang member and a criminal street gang. Then you have Detective Dennis. He gave those same policy requirements. Then you have Detective Gaither. She gave the same ones. Mm-hmm. It is my understanding that the next two, which is Detective Underwood, which is UNDERWOOD, and she's going to testify, I assume, I don't know because I have no reports, similar policy. And then you have Investigator Viverito, which is VIVERITO, also with the City of Atlanta Gang Division of their policy. All of this is cumulative. All of this, I have zero, none of us has any type of documentation. And the way I understand the rules, an expert, yes, they can rely on hearsay, they can rely on the opinions of others. I understand that, but when asked and when you testify, you can challenge those opinions and those statements, so you have to know who said them to you, and all that has been kept from us. So that is, I filed a subsequent motion that it's cumulative, that how many experts you need. Judge Glanville said, it may be getting cumulative, but he did not rule that way. But he said this could be getting cumulative, but he allowed the next expert to testify, which was Detective Gaither. And then I don't know how we have no reports when there's a written order, but we have zero on it. And it's hard when the expert is just saying, or the witness is just saying, well, I do this, I'm on the street, I know these people, Brian Steele, you don't know how streets work. And I go out, and this is how I get information. People will talk to me because they know that I won't put it in a report. Well, that makes it pretty hard to say, well, I don't think the jurors should just rely on your word. I'd like to know who that witness was. Well, I'm not able to tell you. I don't want to tell you. I can't tell you because I left the office. That's the issue I'd like you to address.
Okay, well, I understand the frustration. If there is no report, there is no report. But what was the date of the order that Judge Glanville issued that you referenced?
It is, and it was emailed to your Honorable Court's co-worker
thank you.
at 11, which is November 17, 2023.
Okay, 24?
No.
23, 22?
23.
23, okay.
Thank you.
All right, and that's, unless I specifically change what's been directed in an order, all of the orders that have been issued continue to apply. So I'll expect the state to abide by the requirements of that order. And we'll have to address whether the other experts might be cumulative. Besides these gang experts, are there other experts who you believe there should be reports for that you don't have?
From my knowledge, unless my mind is not working. I believe I have reports on everyone else.
Okay. Anybody else?
That's my, if I misspoke, but that's my understanding.
For any of the other defendants, anybody believe there are other outstanding expert reports that you don't have? Hearing silence, I assume it's just those. Okay.
Your Honor,
Yes,
may I briefly address the court related to this matter?
you may. And one thing before you start, I want to ask, and I could be entirely wrong, but with regard to the experts that are being recalled, I would assume y'all are trying to present your case kind of in some semblance of order. So it may be that right now they're testifying as to ABC count, and later they'll testify to XYZ count.
Correct, Your Honor.
Okay.
There's some witnesses who were fact witnesses, so to speak.
Okay.
So a specific part of the investigation, and then they also may testify down the road about another
Okay.
investigation.
All right. Is that all? Yeah, go ahead. And if there was something else you wanted to say, yes.
Your Honor, just briefly, I wanted to kind of orient that as different gang experts that the state have called to the stand, this argument has been addressed or raised to Judge Glanville, and part of it is gang experts, unlike GBI experts on blood or touch DNA, the police reports that the state has related to the underlying crimes. This is obviously crimes that span a decade. So the gang detectives, specifically Detective Gaither, Detective Dennis, they worked, I think, approximately 26 retaliatory shootings after the January 10th murder of Donna Thomas. So they worked as the lead detectives. For example, we have put evidence, you've heard about D'Angelo White. That was a shooting, attempted murder that happened that Detective Gaither and Dennis picked up after essentially an aggravated assault detective within APD had it, because they're gang detectives. So when they talk about, they don't have, as you would have in, say, a scientific report like a 50-page treatise of the Young Slime Life Street Gang. They have worked these crimes, and their reports or warrants that the state has have been turned over. And so the basis that they state their opinions to the, they speak, it's from working the case, it's from talking to people. So
they're
that's
experts based on their experience.
Yes, Your Honor. And part of the issue arises is the reports that the defense is requesting, they do not have. And so, for example, I believe it was Detective Gaither and or Dennis, they mentioned, they know they are retired from APD. So when you ask them, well, do you have some other additional reports? They say, all the reports I made, were in my file. So the state is not aware of any reports from these gang experts that we have that has not been turned over. The state believes that those kind of four corners from this decade of acts in the case don't exist, of like Detective Gaither or Dennis didn't write some large report in total.
Okay. Has the state asked, not the individual detectives who have since retired, but APD, do we have all of the reports relevant to this case?
Yes, Your Honor, and I will defer to my co-counsel because I came on this case in December, but my understanding is that that has been Chief Deputy Love or Hilton, correct me if I'm wrong, to the court.
Yes, Your Honor, the reports, this is an issue that has been addressed multiple times after the order was entered. Every time that we address either Gaither, Dennis, or Belknap, the issue is raised that there is an absence of a report. Judge Glanville, the court can search the transcript for this. Judge Glanville has addressed repeatedly Mr. Steele's motions and his assertions regarding their lack of a report from various experts. I'd ask that the court review that portion. You do a search for the word expert or report.
I'm not going to do that. Sorry.
No, I don't have any problem with that, Your Honor. My point only is that we've addressed
Got
that.
enough to read besides searching for
that
expert.
issue multiple times.
Okay.
And Judge Glanville has ruled on Defendant Williams' repeated motions for a report of detectives Gaither, Dennis, Belknap, our gang experts. Judge Glanville has ruled on that even after the order that was entered. So I don't believe at this point that there is any further ruling unless the court wishes to reconsider the rulings that Judge Glanville has previously made. I don't believe that there is any further matters to be ruled on as they relate to expert reports and the gang experts that the state has identified for the defense.
All right, just make sure that you have abided by and continue to abide by the order issued on November 17th, granting the motion for complete witness list and expert reports and analysis and findings, okay?
Your Honor, may I respond to that briefly?
Yes.
And I was going to provide one case to the court.
So,
either before or after.
okay, all right,
Mr.
yeah,
Shaw.
no, we'll let Mr. Atkins
Thank you.
finish. Let me, and Mr. Steele quoted it for us, but what the order says is all expert reports, their analysis, findings, and the basis for same must be provided to counsel for each person accused instanter, which means immediately. So the way I read that, that means even though this goes beyond what our discovery statutes might require, this order is what controls. And so even if there is not a written report, you need to give to the defense any findings that these experts have made and the basis for those findings. Okay, just make sure y'all understand that.
Yes,
All
Your
right.
Honor.
Okay, go ahead.
The case, and I apologize, but it's Hassan v. State, which is a March 19th, 2024 Supreme Court of Georgia, Hassan v. State. The version I pulled up is from when it was just pronounced, so it has...
What's the
Site.
S24 number?
It is, Your Honor. So I need to pull up another version. I have the version I saved when it first got published, so I have a 2024 Georgia Lexus 7.4.
Well, that'll work. 2024 Georgia Lexus
7.4, and then it gives a Westlaw.
7.4?
Yes, Your Honor.
All right, I don't use Westlaw.
But what I wanted
I
to...
used to, I just don't anymore.
I've only used primarily Lexus, Your Honor.
All right.
What has came up briefly in defense counsel argument, but gets brought up is this case is important because it discusses when, for example, gang detectives are speaking about. Typically, experts can talk about or rely on hearsay to make their expert opinion. So when you have gang investigators who have spoken, talked with a number of people, part of their response or expert opinion on XYZ is based on years of experience. And so this case has an important holding in relation to specifically, neither witness expressly repeated the out-of-court statements of any other person, although the detective testified that he was familiar with the Ramsey investigation, which was some other investigation he was talking about, and referred to speaking with another detective who worked on it. He did not specifically state what the other detective told him or how he developed his familiarity. So it was not obvious that the evidence was hearsay, such that the trial court should have sua sponte excluded it. And this was a gang case where, kind of like how Detective Gaither, Dennis, and then Detective Viverito down the road, they reached their conclusions. And so if they are not directly deriving what their statement is from hearsay, as an expert, this case is helpful to illustrate in the context of a gang expert how that can come up. So I just wanted to share that, Your Honor.
Appreciate it.
Thank you.
All right.
Thank you, Mr. Sharp.
Okay.
So, Your Honor,
Yes.
I don't want to be taken as crying over spilled milk, but I'm really just trying to bring things to your attention. Miss Love referenced in kind of, I feel like I was the one that was making the most noise about the reports, especially investigators' reports. And the reason I was doing that, and we're not talking about expert testimony right now, reports by an expert. These experts were also testifying as fact witnesses.
Right.
And there were several times, it was Investigator Gaither, and I believe it was Investigator Dennis. I could be wrong on that, but it was definitely Investigator Gaither and another investigator. I think it was Dennis. And they they testified to doing things in these cases. And we're looking at a lack of reports indicating that these tasks were done, showing photo lineups to certain people, interviewing witnesses. And I complained about that. And I said, well, where are the reports? Because at first I was, in cross-examination, well, wouldn't that have been something you would write a report about? And they said, well, we did write the reports. And so we met out in that side room with Investigator Gaither, but I believe Investigator Dennis, we also talked to him, and they insisted that they wrote reports about this work. And it is correct when they said, when we left, we're retired, we cannot access the reports, but we left them with APD.
Okay.
The state has stated that they don't have these reports.
All right, that should not be happening. We'll take that back up when she comes back in here, whoever she is.
The state has stated repeatedly that they don't have the reports, and I think all of us are left in this quandary where the state's saying they don't have reports, but the witnesses are saying we wrote reports. And
Okay, do you have dates for any of that? Or have you previously discussed with counsel for the state
well, when I brought this up to
what you think is missing?
yes, well, unfortunately, those witnesses have already testified. So, of course, I would like the reports. But going forward, and the part of my frustration is when the state says, we don't have reports, and the witnesses are swearing there's reports,
Right.
so we can't really nail the witnesses on it, and the state's saying, well, we can't hand anything over either. Then we talk about it, and the court at the time just kind of said, well, there was a hack in 2018. And
That's actually what I was literally about to say, is it's possible that for some of these things, I mean, we all remember, we were all around in 2018, the city of Atlanta there was some huge cyber attack, and lots of things got disappeared from everywhere, wiped out. So if that is the excuse for some of it, it's probably legit.
well, I'm
But
not
it's
saying
gonna
it is
depend on
or
the
isn't
dates.
legit. I'm not saying it is or isn't
Right.
legit, but I'm
happy to bore down on it some more and talk
Because-
specifics.
I mean, it wasn't even, I can't recall if that was even suggested by the state, but that was just thrown out there. Well, reports are missing because of the hack. And I'm like,
Well,
how do
I'm
we know that?
happy, yeah. If you want to get together a list, and I mean, maybe more so for the witnesses going forward, and these, we're at this point not really talking about expert reports, we're talking about police reports, fact basis that ought to be out there. And if you want to in detail get that, because that is frustrating for everybody. I mean, yeah, it's out there. You wrote it down. So unless it disappeared in the cyber attack, it ought to still be able to be gotten, even if not by that witness, because that witness is retired, by the state, because the police and law enforcement are a part of the state. And so it is within the control, if not the custody of the state. So I'm happy for us to bear down and bore down and drill down some more on that. If y'all want to give me specifics, or if you want to, well, give both to me and share with the state specifics, because that will help them as well, to not just say, hey, APD, please give me everything about this case. But there should be a report from Detective Gaither dated August 2nd, 2000, about a lineup she did. And then they can actually search for something. So let's, to the extent y'all want that, and you're certainly entitled to it, let's get details together so that we can give that to the state, so they can give that to APD, and we can actually hopefully find something if there is something out there but missing.
Yes, Sean.
Okay.
Thank you.
All right. Yes.
We
Yes.
turned over to defense. Every report from 2015, every report that the experts have referred to or will testify about, and the complete case files that exist for each of those reports.
Okay.
So we've turned that over. If I will await defense giving to us what they now posit they don't have,
Okay.
that we have not already addressed.
Okay.
And, Your Honor, I am asking the court to refer to Hassan versus the State, 318, Georgia 673. It's a 2024 case that, that's the full citation of the case that
Okay.
Mr. Atkins just cited.
Oh, perfect. Thank you.
Your Honor, I mean, with all due respect to everyone here, that's a bit disingenuous
I think
because
is your mic on?
I'm turning it on.
Maybe we need to take a look at that and see if it's still working.
With respect to everyone here, that's a bit disingenuous to say, well, we're raising this for the first time. We had the issue in court with Investigator Gaither. The state is very aware of what those reports are. I'm not saying I know all the answers here. All I'm saying on those previous occasions, there wasn't, in my estimation, from my vantage point, there wasn't a lot of effort, and it was just blame the hack.
Okay, well, thank you.
Yeah.
And I don't want to keep going back and forth with blame or bashing. I want us to be productive and talk detail so that we can make things happen. So, thank you. All right, what else, if anything, that we can deal with today? It's okay to say that's about it for today, because I've got some homework anyway. All right, so we will adjourn for the day, and we will see everybody's smiling faces at 8:45 tomorrow morning. Thank you all.
Your Honor, before the court...
Oh, yep, there's one more thing for me too. Go ahead.
there is a scheduling matter that we would like to address with the court.
Okay,
With a member of the bench at the bench.
okay, come on up. And I guess one person from each team. Earbuds and what have you over here that I have never used before. And if we're going to be using those during the trial, I would like a little bit of practice on them before we get in front of the jury. So maybe, you know, the next day we end at 4:30. Y'all remind me and let's all figure out how those work, because I don't know yet. All right. Are you just going to be representative of everyone?
Yes.
Sounds good. the state, due to a scheduling matter, may want to, whenever we do pick back up with the jury, which hopefully will be soon, but I'm not sure yet what all we're going to get finished with this week. If we bring the jury back next week, there is a request for the court to consider having a witness who is not Mr. Copeland be the next witness because of a scheduling matter for the attorney who was examining Mr. Copeland. Now, we have to redo at least part of Mr. Copeland's testimony anyway. I don't know if that's an issue to y'all. We're gonna have to come up with whatever we're gonna say with regard to, you may be hearing a lot of this again and you're gonna need to disregard what you heard before. We'll have to work on that and y'all be thinking about that. That's y'all's homework. But is there objection to moving to another witness and coming back to Mr. Copeland? And if so, what is it? And then I'll consider whether I'm going to permit it or not.
There's an objection to going back and telling the jury anything about disregarding Mr. Copeland and having to do it all over again. It's impossible. There's no way in the world.
All right, well,
The jury
yeah.
just disregard Mr. Copeland.
Okay, but that's not what I was asking. I understand that you just think that is a total disaster and makes this trial one that needs to be a mistrial. I understand. But that aside, just with regard to scheduling, assuming we are going to go forward for the purposes of this discussion, and assuming that, I mean, y'all don't stipulate to everything he's already said and that we have to redo a part of his testimony, well, whether we do or not, we're going to have to continue his testimony. So is there an objection to essentially taking some other witness out of order in the midst of his testimony?
Your Honor.
Yes.
Keith Adams on behalf of Mr. Williams. Mr. Steele and I have consulted about that. And I don't purport to speak for anyone else. We do object to that. We believe that given the complexity of Mr. Copeland's testimony and the issues surrounding his testimony and the confusion that will probably already attach to a jury coming in and seeing some of what Mr. Copeland's heard and testified to and possibly having to be instructed about disregarding some of his testimony, we would object to going to another witness.
All right, I appreciate it. And I think with that objection, you know, it's well-founded. So y'all do what you have to do with regard to who might be handling the examination, but we will pick back up with Mr. Copeland and finish with him before we move to another witness.
Would you allow another member from the state to continue his examination?
Considering that we're going to have to, well, as I understand it, there are a couple of days of, and I don't know whether y'all got testimony out of him or not, or if it was just a discussion of whether he was going to plead the fifth or all of that. If there was there testimony from Mr. Copeland prior to the motion to recuse on the 12th?
Yes, sir.
Okay. All right. Considering that Ms. Hilton handled that testimony, and we don't normally switch attorneys mid-witness, there is now a request on the floor to do just that, to switch attorneys mid-witness. We're switching judges anyway, and we're redoing some things, so it's a little out of the ordinary anyway, but if there are objections to that, I will entertain those.
Well, may I speak?
Yes.
I would hope that that's not an issue. As of tomorrow, when you rule on the disqualification,
so that Ms. Hilton can go wherever she would like to go. As far as I'm concerned, we will not call her for several months. Who is the witness that would be substitute? I heard what Ms.
I don't know. Do y'all have another witness in mind?
What is the hiatus? Is it a week? Is it
I don't know that either.
Would be 1 week, Your Honor, would be my absence, would be 1 week. Your Honor, we do have several witnesses. It would be the state's intent to potentially just go in order of who we have kind of listed. So we wouldn't be calling anyone from the bottom of our witness list, but it would be someone within the same act that we're.
So you just essentially skip over him and go to the next witness on your list and then come back to him.
Yes.
But I've kind of already entertained an objection to that and said, no, you can't do that. So the question on the floor at this point then is if we're continuing with Mr. Copeland and not picking up with another witness in the middle, is there an objection to another prosecutor handling the remainder of his testimony and whatever needs to get redone?
We just have a moment.
Sure.
Speaking only for Mr. Kendrick, Mr. Kendrick objects.
Okay. And on what basis? Because you want to make it difficult for the state.
No,
Which is fair.
Well, no, Your Honor. This whole thing is messed up.
All right.
We've got to redo this witness. We
All right.
can't redo the witness.
Okay.
I don't even want to get started. So switching out the questioning attorney
All right.
is just even more complicated.
Okay. So let me take that part of this under consideration. All right. Okay. So the other thing that I had
Your Honor.
is I
Your Honor.
asked.
Judge?
Yes.
I'm sorry.
yes.
I'm sorry. Didn't speak
Oh, I'm
quick-
sorry.
No, that's
Did you-
okay. I didn't speak quickly enough, or my microphone didn't come on quickly enough.
We'll blame it on that.
Yeah, it's the microphone. Just to be clear, on behalf of Mr. Williams, we don't have an objection.
Okay.
And I don't believe, I'll let everyone else speak for themselves, but I don't believe there are any other objections back here.
Other than the one already voiced by Mr. Harvey.
All right,
right.
so that's just us.
Okay.
I object to Mr. Adams making me look bad.
Okay, well, so noted. All right. Well, I'll think about that one. Okay, so there had been Miss Love put on the record this morning that she had made the request for the Monday morning meeting. That was the June 10th meeting with Judge Glanville and Miss Bumpus and others at some point in the afternoon of the Friday the 7th, and I said I would get that ex parte because it did get taken down. And so I reached out to the court reporter who handled that, and she has given me a rough. Now this, and I'm going to share it with each of you. It's a rough, so this is not the official transcript, but I mean, she's an experienced court reporter, and this is probably pretty close to what it's going to be officially. But anyway, I'll just share that with each of y'all so that everybody's on the same page about everything, okay? So if y'all all want to come up here and get a copy from Ms. Pursfield, after that, we will be in recess for the day. Thank you.
Relates to the ex parte.
Yeah.
I could be wrong about this, but I'm asking my colleagues, and no one has the written motion for immunity for Mr. Copeland.
Okay, I think that probably got filed ex parte, but is there any objection at this point in time in the defense having that as well?
No, Your Honor, not
Okay.
just the defense, no. We
Okay.
just didn't want to, no objection to the defense having it.
Okay, so I'll email y'all if that's okay, because I don't have hard copies of that available. A copy of that. Do y'all have the order?
We have the order.
Okay, yeah, I'll make sure y'all have a copy of the motion. Okay. Third time's a charm, we're in recess? Okay.
Thank you, Your Honor.
Thank y'all.